Yes, Mr. Monica. What means rule 3? Did I direct? Then all my directions are for payment, release.
The order amount to the trial court lordship.
So very well go before execution.
Lordships, I have submitted a petition. Since they are saying that the High Court order, this court cannot do anything, lordship.
No, the direction was only for 6 weeks.
Yes, it is already gone 10 weeks done, lordship. 10 weeks done, lordship.
So then the trial court should pass an order in your order, and then you move a CRP out here. They'll pass an appropriate order. How is it possible that when there is no stay, they have done this? Don't worry.
Lordship, I beg to mention for listing of an IA, Lordship.
Why?
IA in connection to MSC appeal, so delay IA, but actually execution process has been initiated. Probably on next week, Lordship, Wednesday.
When?
Wednesday.
No. You don't have any urgency in those matters. We'll have it on 11th of June.
But execution have been initiated. Lordship.
Let it be executed.
11th
Then you will
June.
realize that whenever you have to pay and recovery, then those matters you get stalled out there
No,
by
this is
adjourning the
not
matter 1 month.
This is on different ground. Also, I have another Lordship regarding item number 55 of the supply list. Okay,
50?
last occasion, Lordship has asked us to take some instruction from the insurance on 23/5. We are still awaiting the instructions, Lordship. So some time may be granted.
This is also cyanide.
Yes, Lordship.
This is এইটো কৈ দিব এই যোৱাকালি এটা অৰ্ডাৰ দিছিল নহয় MAC পৰহি এটা অৰ্ডাৰ দিছিল নহয় MAC 208 যোনটো অৰ্ডাৰ দিছো এইটো 6 for an accommodation in ASR, and he doesn't know when the instructions are coming, and as such the matter stands to adjourn cyanide to be listed only upon an application being filed by the counsel for the petition appellant before the registry.
I'm obliged, Lordship.
Other is on 11th.
May I please, Lordship? I beg to mention item number 18 today's list. Lordship, my senior engaged counsel could not conduct the case today. My senior engaged counsel is out of station. Lordship, kindly adjourn the matter.
What is the matter about?
CRPIO.
You want an accommodation?
Lordship, I am not aware of it. I don't have case record with me.
Your name is P. Sharma.
No, Lordship, E. Devi.
Then
I
you are
am
nowhere
appearing
there.
on behalf of KU Ahmed.
Ask
sir.
anybody who is there.
Lordship, I am appearing on behalf of KU Ahmed, sir.
How do I know? How do I know? You are appearing on behalf of anybody.
I-
Your name is not there in the Wakalatnama. But later on the person comes over. How do I know that you are attached with KU Ahmed? How do I know? Tell me. Give me a good reason. How? You don't have the file with you. Then, if you don't have the file, how do I believe that you have anything to do with that matter? Give me a good reason. Why should I believe you? Sorry, can't help you.
For motion item 1. Lordship, petitioner before Lordship is the respondent wife, Lordship in the family court principal Guwahati, Lordship. She is seeking the transfer of the suit filed by her husband, Lordship, to Nolgari, Lordship.
What?
Because Lordship, The two another cases are pending before the.
So what? Nolbai is so nearby. Why do you need a transfer?
Lordship, Lordship, she cannot come to Guwahati alone, Lordship, and her mother
She
is.
can't come to Guwahati alone. How did she file? Are you saying that
Lordship, Lordship,
you made this? No, 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 no,
Lordship,
no, no.
her, he
Don't make that
comes-
submission
Lordship,
before this court. Are you
she-
saying this affidavit was made at Nolbari?
No.
Then,
She came along.
then how
along-
did, she-
along
then
with
how,
her
if she
father,
can very well come out here, being a 28-year-old lady out here, can come out here to appear out here, why not, not there in the principal civil judge?
Lordship,
How much time does it take from Nolbari to here? So nearby.
Lordship, which is nearby, Lordship, but
Then-
Lordship, is her father accompanied her to while she come to Guwahati to filing Lordship. So, her father is also a retired person as Lordship and suffering from certain ailments, Lordship.
Oh,
Her father, Lordship, and there is no one in the house except her sister who is pursuing her B.Ed course at Samota, Lordship. So, Lordship, she alone could not come, Lordship.
so the next date is on,
Lordship, today is the next day.
go and
Lordship.
appear. File your written statement, we'll consider
Lordship,
that.
Till that, Lordship, I have not received the copy of the petition.
Go there, say that you have not got the copy of the petition, you got the certified copy of all the orders.
Yes, Lordship.
Then, how did you get the certified copy of the orders passed before the court and you don't have a copy of the petition?
Lordship may kindly peruse.
I am not going to Peru, I have looked into Annexure B.
Yes, Lordship.
So if that be so, why don't you make a request out there?
Lordship, Annexure B, Lordship, page 24 a moment, Lordship. There is a paper publication, Lordship, and
So
today-
go there and appear. What is there?
Lordship, Lordship, she have filed two petitions, which is pending for the learned family court, Lordship, and the respondent herein, Lordship, the husband, Lordship, will not be prejudice, Lordship, if the case is transferred from Guwahati to Nalbari, Lordship,
Why?
because, Lordship, one FC criminal case is pending before the learned principal just family court at Nalbari, Lordship.
Where is the petition?
Lordship, I have mentioned the case number.
No, no, no. This is not satisfactory.
Lordship,
You have,
then-
your
then Lordship,
case is on because of your father's
the
illness,
father
nothing else.
and mother also, Lordship. I have annexed the medical document.
Others
Lordship.
also hardly matters.
Lordship, then Lordship.
What are you doing?
Lordship, I have applied for a certificate copy on.
What are you doing?
I am doing nothing, Lordship. I'm at present I am sitting at home, Lordship. I am doing nothing,
What is
Lordship.
your qualification?
Graduate, Lordship.
Then, where did you study?
I studied at Nalbari, Lordship, MNC college.
Produce those certificates.
Lordship, those,
That you are not in a position to come. Always is too near. Sorry,
Lordship, kindly, Lordship, kindly,
sorry.
Lordship, accommodate, Lordship. Then, Lordship, I may be allowed to file on additional affidavit, Lordship, at least, Lordship. Otherwise, Lordship,
Counsel appearing on behalf of the petitioner submits that he will file an additional affidavit. List the matter again on
Lordship, after 10 days, Lordship.
16th of June.
Obviously.
Item 2,
This is also transfer petition matter from Gwalpara to Tezpur. Taking transfer. The wife and children are, two daughters are in my Tardo matter on the way to Halupong, Tawang. So the distance between Tezpur and Gwalpara is 319 kilometers. And the husband took us there, kept us there, got the children admitted in public school because he was in Assam Rifles. So he got the children to be admitted in Kendriya Vidyalaya. Now what he is left, then filed a divorce suit.
Mr.
Involved.
Sharma, what are you doing?
Actually, I'm not doing anything. I'm in the parents' house.
Huh?
I'm in the parents' house.
Okay. Since when?
Since my lord, since the date is not given, with the elder daughter is now the CA and younger daughter is higher secondary. From
Issue notice making it returnable on 23rd of June 2025. steps be taken by way of registered as well as usual. So in addition to that, the petitioner is directed to effect service upon the respondent by way of Dusty routed through the registry of the spot and
Dusty,
file.
my lord. Dusty.
Dusty.
He is in Manipur, my lord, Assam Rifles.
Huh?
He is in Manipur, somewhere Manipur. He is serving in Assam Rifles, my lord.
So?
Hello?
So,
I have always
why have you put the address out here as Gwalpara then?
Walpara is.
You know it very well that his address is in Manipur.
No,
Why
he
you
is
have put it
after
as
the
Gwalpara?
Today he is in today he is in Manipur, my
Then
lord, Assam Rifles. Tomorrow he
correct
will
your
be in
address. Sorry.
No, his permanent house is Walpara.
Then I'm asking you, you have to effect service by way of Dusty, no, otherwise no stay.
That Walpara is fine. Okay, I'll do.
By way of Dusty, routed through the registry of the spot and file an affidavit of service on or before the next day. The petitioner herein has filed the application under under section 24 of the Code of Civil Procedure 1908 seeking transfer of title suit divorce case number 19/2025 pending before the court of the learned district judge Gwalpara to any other court in the district of Ponitpur, Assam. The reason assigned in the instant application is that the petitioner resides with her parents at Soridwar in the district of Ponitpur, and it would be very difficult for her part to contest the proceedings which is pending before the district judge Gwalpara. It has been also stated that the petitioner has no source of income. And no source of income. Taking into account the said, in that view of the matter, this court is of the opinion that the petitioner has been able to make out a case for stay of the further proceedings of title suit divorce case number 19/2025 pending in the court of the district judge Gwalpara till the next date. Accordingly, further proceedings of title suit number titles TS divorce case number 19/2025 pending before the court of the district judge Gwalpara shall remain stayed only till the next date.
State till next day, my lord.
Subject to the stay.
That's of course.
Don't affect service.
Whatever, my
I'm going to vacate.
just my lord, that is gone, my lord. Whatever, my lord, she is in Chardwar. From Chardwar to Tekul, she will come for one bus.
Ask your able junior, ask anybody from any. I have not asked her to go there.
Yes.
I'm asking you or your able junior or any clerk to go and serve it. And
No,
thereupon,
I got rest will serve it through the state. I got rest will serve it. Only I am to bear the cost.
it is your lookout.
Item 3 to 15.
Hello, LC आता है ऐसे नहीं. Right? उसको क्या? Really क्यों?
Yes, yes, my lord. Now, Lord, the issue in my humble submission before your lordship is whether CPC is applicable to the proceedings before district judge under the Telegraph Act or not. That's a pointed issue, and that issue arises, my lord, in my submission because we did not get opportunity to place materials regarding accord and satisfaction limitation, my lord. Accord and satisfaction in limitation, my lord. On that issue, my lord, I straight away wish to place the judgment of the Honorable Supreme Court dealing with the Telegraph Act only, my lord, 1976, 4 SCC 634, my lord. That will be part of it. have.
Last time, did you give that?
Yes, yes, your lordship, I have.
Hey, या लोगों ते तो yes, where is that? या लोगों judgment किस में दिसेल? खुद बोलो.
My lord, we have another.
History में तो. Yes.
Lordship, kindly come to page 47 of the judgment of 1976, 4 SCC, page 634, my lord. Paragraph 4, my lord. At page 48, my lord. On March 10, 1972, respondent filed petition before the district judge, Telecherry under section 16(3) of Indian Telegraph Act 1885, claiming an enhanced compensation of rupees so and so. The board raised several objections. One of the objections was that the petition was barred by time under Article 137 of Limitation Act. The board contended that notice intimating the fixation of compensation was served on March 4, 1969. Therefore, petition was barred by the Limitation Act. The respondent contended that Article 137 of 1963 Limited did not apply to the application of district judge under the Indian Telegraph Act. District judge held that application was governed by Article 137 of 1963 Limitation Act, and therefore the petition was beyond 3 years and barred by time. The respondent filed revision and High Court applied, and High Court condoned the delay in filing. Then your lordship kindly see paragraph 20, my lord. Paragraph 19 and 20 at page page 51, my lord, paragraph 20.
So?
Paragraph 20, my lord.
Read it. Where does it say?
Yes, your lordship, kindly, paragraph 20. my lord. The provisions at the page 51, bottom, my lord. The provisions of Telegraph Act which contemplate determination by the district judge of payment of compensation payable under section 10 of the act indicate that district judge acts judicially as a court. By statute, matters are referred for determination by a court of record with no further provisions. The necessary implication is that court will determine matters as a court. See so and so. In the present case, the statute makes the reference to district judge as the presiding judge of the district court. In many statutes, the reference is made to the district judge under this particular title with the intention to refer the court of district judge. Telegraph Act in section 16 contains intrinsic evidence that district judge as mentioned there as a court of the district judge. Section 16(4) of the Telegraph Act requires payment into the court of district judge as such amount as Telegraph Authority deems sufficient if any dispute arises as to the person entitled to receive. Again, section 34 of Telegraph Act refers to reference. Telegraph Act reference is made to payment of court fee and issue of process, which are suggested that ordinary machinery of court of civil jurisdiction is being made available to settlement of these disputes. My lord, I am emphasizing on these lines. Ordinary machinery of civil dispute, my lord. Section 33(17) of the General Clause Act states that district judge in any of the central act of the central means the judge of principal civil court of original jurisdiction, then the High Court in the exercise of original jurisdiction, unless there is anything repugnant in the context. In the Telegraph Act, there is nothing in the context to suggest that reference or to district judge is not intended as a reference to district court, which means that the meaning implied by definition applicable thereto. District judge under Telegraph Act as a civil court in dealing with application under section 17 of the Telegraph Act. So my submission is, my lord, that district judge, district judge acts as a civil court. And once it acts as a civil court, my lord, it exercises the power under section 141 of CPC, my lord, because CPC will get applied, my lord. There are two more judgments on this proposition by two high courts, my lord. One is Andhra Pradesh High Court and one is Kerala High Court, my lord. First, your lordship, kindly see 2005. Second comparison is 2005. Because it is a civil court, my lord, and Page number.
Which one?
Lordship, kindly see 2005 SSC online AP 913,
Where is it?
page 32,
Of the second compilation?
second compilation. Lord. In this case, my lord, the issue was the power of district judge to award interest and on the basis of section 34 of CPC, my lord. That issue your lordship will find at paragraph 4, my lord. Paragraph 18, my lord. Paragraph 18, my lord. And 19, my lord.
Then
19, your lords. Paragraph 18, my lord, is that
18
Ramchandra
already,
Rao's whole
19,
case.
then
Paragraph 18, sorry, paragraph 18, my lord. In fact, as laid down in Ramchandra Rao's case, under the section 16 of Telegraph Act, the exercise of power by district judge are as a court and not in capacity of personal designator. Further, it was held that it is manifest that determination of civil rights of the kind being normally the duty of civil court, the act has for the object and purpose getting dispute as to the sufficiency of compensation determined finally by the principal court of original jurisdiction without much expense to the parties. Language of section on its proper construction also makes it clear that reference to district judge therein is no other capacity than a civil court. As a matter of fact, sub clause 4 of the same section, there is a reference to the court of the district judge. It is reasonably clear that reference to district judge is no matter apart from the capacity as a civil court of principal jurisdiction. It
Mr.
may
Counsel,
further, paragraph
this-
19 is.
Mr. Senior Counsel,
Yes, madam.
whatever this court must have said, but the power you get it from the Interest Act. You don't need to go for the purpose of section 34. 34 is a procedural power.
Yes, madam.
The power to grant interest is if there is nothing provided anywhere, you go to the Interest Act.
Yes, Lord.
That is the substantive power.
Yes, madam.
So how does this help
But
you?
in this case, my lord, the issue was paragraph 19, your lordship kindly see. In paragraph 19, the issue was that it is a civil court, my lord, and in 34, the objection was raised by saying that the trial court cannot invoke section 34 of CPC, my lord. In that context, paragraph 19, the court held that it is a civil court and all civil proceedings will apply.
You said that you don't want to adduce evidence.
You will not, if your lordship will see,
Already the 20 no.
my WS, my lord, my
No, your
WS,
WS, forget about your WS.
yes, my lord.
In one of the matters, Miss Petition number 3 of 18,
Yes,
which
my
is there, on 29/9/2023, you said that we don't want to adduce evidence. And now you are saying that you are not given an opportunity.
I say, my lord, is this, my lord, that I set up a case that it is barred by limitation, my lord. I set up,
For that, you have to adduce evidence that where is the dispute.
yes, my lord, for that, my lord, the
Okay,
issue.
now how many
out-
dates have gone?
Yes, your lordship, kindly see, I
Okay.
said that the issues have to
Now,
be framed, my lord, two things, my
Mr.
lord.
Kumar, you
Yes.
give me the dates when the orders are passed. Let me dictate the order now.
Your lordship,
No,
kindly
no,
give me one-
remaining
one
you go
more
to.
judgment, my
No,
lord.
no, no.
And one more point, my lord,
No.
one more submission,
Yes,
my lord,
please.
one more. Now, the only submission which I have, my lord, before your lordship, that I said in my WS, my lord, that the claim is satisfied, barred by limitation, my lord. The issues were not framed by the learned district judge, my lord,
Raise that.
because
Are you aware of the fact that there was an amendment also made? There was an amendment sought for amendment was allowed when you were asked to file WS, you said we are not filing additional WS. No, in this case. Now, in this case, this is pertaining
Item
to,
50, sorry, item
this is
33,
pertaining to the
item 3, my
response.
lord, I have item 3 before me, lord.
No, Kamrul Islam case, which is there was an amendment made.
In one matter, my lord, your lordship, that may have taken place, that I do not deny. my lord.
Did you say that you are going to adduce evidence?
My lord,
No.
No, I did not, my
Then-
lord, I did not. I can't say anything more, my lord.
Now give me the
What-
dates when the orders are there.
Your lordship, kindly see one aspect of the matter, only one aspect of the matter is that I pleaded, my lord, that the claim is barred by limitation. I pleaded that there is an accord and satisfaction because all those papers are there. with-
Page that.
Your lordship will see.
Let us see your submission. Where
Yes,
they
my lord, my
record and
plea,
submit.
my plea is, my lord, will page 20, page 25 of the first matter, my lord, item 3.
Okay. CRP
The
51.
29, my lord, is my WS.
Yes.
Twenty-nine at page paragraph 3, my lord, I say that it is barred by limitation, my
Okay,
lord.
then,
And then, my lord, I place the facts of the trees, their life, their everything, my lord. And after that, my lord, giving details, my lord,
receive the amount of.
At page
Iman after
35, my lord.
adjustment of Iman in respect to the other trees and crops and so for the same could not be retrieved due to lapse of time. The claimant so and so is admitted by the petitioner to Axis Bank and so. That the answering bill is submitted to with the help of revenue staff as per the prevailing rate of 2014 and 2001. Where is your statement?
my statement starts, my lord, from page,
I understand, Mr.
Yes.
Mr. Kumar,
Yes.
can you tell me one thing? Where have you stated, when did you make the payment?
that state, so for my submission is, my lord, that that the issue should have been framed and I should have been allowed to lead the evidence, my lord. And 35,
See,
I,
Three
it is
dates,
a
3 dates.
general board, because the lordship has seen that under section 10D, section
So
10,
each matter.
section 10D, my lord, the
25,000.
date on which I passed the
25,000 each cost.
my lord, your lordship, right? Your lordship will kindly appreciate, my lord.
No, no,
that
no,
this is
no.
not-
Mr. Kumar, I have given you enough indulgence in this matter, enough. I have given enough indulgence to the Power Grid Corporation in respect to this
My
matter.
lord, this is not the only, just one matter, so we have no issue, my lord, whatever, because this. there
No,
must be
no,
other
no.
matters
First of
also.
all, first and foremost, you say about the delay and you approach this court after 2 years.
Yes, my lord,
This is the explanation. And you have not paid.
we have paid the.
You have not paid after the award being passed. What is your explanation?
Yes, my lord,
This is a pure and simple case by which you are not giving any importance to an order being passed by a district judge.
It's
You
not-
have flouted section 16 or any adjudication made under section 16?
We are before your lordship, because in one of the matter, my lord, the even matter was remanded back by the.
Show me that
court.
order.
Yes, your lordship, that is. That- Lordship, this CRP 115 or 2020.
You have given the compilation.
It was separate. Give me soft copy. May I pass my copy?
No, you give them, they will take out the certificate, printout. Give it.
Yes, CRP.
On the ground of limitation.
On the ground of limitation, but in that case, my lord, I must say that there was a gap. There was date of assessment and the date of the order was, but on that issue, matter has been remanded back for framing of the issues and giving parties liberty to lead evidence, my lord.
In this case, if
Yes,
you
sir.
see.
Yes,
Go ahead. In this case, if you see, the difference out there is,
Yes, my lord.
first of all, with due respect to my learned brother, 130, he have merely taken into account that there is barred by limitation, a statement was made.
Yes.
Without taking into consideration that there was, the bar will only act if there is a question of dispute, which is the basis on which a right to accrue under 137 will apply. There is no discussion. Here, the learned brother have referred to the judgment of Kerala and the other two judgments, which are obviously there is no consequence to that. There is no doubt. if a plea of limitation is taken, very well, the plea of limitation has to be taken as a point for consideration. There's no quarrel with that proposition. But the question is, if a plea of limitation is being taken without specific facts,
Whether issues, your lordship,
which are the framing of issues? This is the use of a word being taken by the learned, by learned brother out there.
Yes.
And on the basis of a submission, on the floor of the submissions, the judgment was made.
Yes.
But the fact remains out there that when a plea of limitation is taken, and specifically, there's no quarrel with that proposition, that if a plea of limitation is being taken, then look here, it is barred because the dispute arose on such and such date, and this is being filed after say.
Yes.
Here the dispute says that it was the dispute arose in the year 1999, and it was filed in the year 2006. And this very aspect was not taken into consideration. Whether you frame an issue or not is immaterial. But the fact that when you have raised the plea has to be answered.
Yes.
But the fact that when you have raised the plea that there is a dispute, when the dispute arose, it has to be also on the basis of evidence.
yes, my lord.
There's
That,
no evidence.
so my difficulty, my lord, is, lordship is right. My difficulty is, my lord, that had the issues been framed by the trial court,
Why didn't you raise that issue there? Why didn't you raise? Are you
Because the
saying that there are
lordship will see-
lawyers out there didn't know how to conduct the proceedings?
your lordship,
Where, first of all, the question of framing of issues does not arise. This only one thing good about these matters coming out here, that this court will put it properly as to how a proceedings is to be taken into
Yes.
account.
your lordship, if your lordship will see the impugn order, the issues have been framed by the learned district judge on his own at the stage of final judgment, my lord.
Okay, let us be very technical on the CPC.
Yes.
What is order 14 rule 5?
That order 14 rule 5, my lord,
Yes.
because order 14 rule 1,
No, forget about 1. Let
Yes,
us
sir.
come to order 14 rule 5.
order 14, kindly, I'll raise that. Yes, but beside that would be order. Five is, my lord, power to amend and strike out issue. The court may at any time before passing a decree amend the issue or frame additional issue on such terms as it thinks fit, and all such amendment or additional issues as may be necessary for determining the matter in controversy between the parties shall be so made or framed. So,
So that issue can be made, everything done. Then also at the time of writing the judgment, he can frame that issue.
yes, my lord, but if you.
When you have stated that you don't want to adduce
In one
evidence, where is
matter,
the
my lord,
question of
in
these
one matter,
pleas?
my lord, I may have stated, my lord, but in the other.
Are you making a statement at the bar that there is no statement being made
I
that
will
you have,
not- I
you
will
have,
not-
you have said
Yes,
that
I
you are
will
not
be-
going to
I will
give
not-
evidence?
Lord, I will not
Then
make that.
don't
unless I
make the
see that
submission.
statement. I will not
That
make
is
that
why
statement.
one record
I'll-
is here and I've seen that record. Your specific case is we don't want to adduce evidence.
So will not is because I would have led the evidence on sufficiency or insufficiency only, my lord, that is the
Why
only,
didn't you do that?
that is one aspect of the matter.
Why
But
didn't you do
the
that? Who
second
had asked you
aspect
not
is,
to
my
do
lord,
it?
Second aspect, if the issue would have been framed, my lord, two issues, for example, whether it is barred by
Okay,
limitation.
now let us come to the detailing of the matters. Mr. Kumar, I have heard you. Now let me dismiss your petitions by giving
And
us.
that one more plea, and then
No,
I'll
no
leave it
more
thereafter,
plea.
my lord.
All these pleas, let it be under one,
My
let
lord,
it
I'll
be,
then-
let it be taken into consideration by the Supreme
One
Court under
submission is that
156.
coordinate bench has taken a view, my lord.
Don't worry, Mr. Kumar, in front of you, I am going to pass the order and you will see how I distinguish it. Don't worry. Don't worry about that. I know how to take care of it.
Yeah,
Now kindly come
I
to
would
the
say-
detailing of these matters. Hey, good day, the file. Please.
And one, my lord, that your lordship is right, that issue. If I have the documents which shows that they have accepted and the money and said that this is to be their record and satisfaction, my lord, if your lordship can see.
Absolutely no. I'm in 227.
I know your lordship, but that is why I wanted these matters to be placed and I should get the proper natural principle. We are not,
Are you therefore alleging your advocate was not properly instructed?
lots of.
Why on earth didn't you bring this document when you filed your written statement?
I should have been brought, my lord, but
Why are you making up all these things?
the issue is that, my lord, this person has
And that
received
too
the
after
money.
2 years.
They received that money, my lord, at that point of time, and it is definitely barred by even from the date on which he has received, because I prepared a chart, my lord, on various dates he has received and filed a suit. They are all beyond 3 years, my lord, on the face of it.
Let us see your chart. That chart will help me in deciding, dictating the order. Yes. So these detailing of submission of these checks which were there
Yes, my lord.
was not mentioned in your written statement,
Yes, my lord.
in any of the written statements.
Yes, my lord.
There was no evidence also adduced.
Yes, my lord. That is right, my lord. But thing is that the person who filed the suit, my lord, a claim, he says that I have received the amount. And I'm not even in the claim petition, my lord. Your lordship will find only what he says, my lord, in the in the plaint before the London district judge, that I require higher compensation. He is not also making any averment in the first matter, my lord, item 3. I have seen the plaint. If I can take your lordship to the plaint, my lord, he says that give me higher compensation only. He doesn't say anything what amount, and all these issues, if your lordship will see, please 26, 27, paragraph 7.
Yes.
That the petitioner received total amount of 5,76,300 only were paid by OP as surface damage, and now praise for enhancement, which is reserving right to claim after assessment list from OP after deducting the compensation paid earlier, and for diminution of and utilization of in addition to interest. Therefore, the honorable court in respect of damage so and so, my lord. So amount is also not mentioned. If
Huh?
the amount comes in the evidence of the plaintiff, my lord.
That is also being taken care of by another constitution bench judgment in the case of that Paripuran, I suppose. There the Supreme Court says how much he claims is immaterial. What should be given is the just and fair compensation.
And 37 also, your lordship will see 37. The summons have been issued under the CPC, my lord. Summons to the witness, my lord. That examination in chief is also under the CPC. So once all.
So no, not only that. They have also amended it as per Order 6 Rule 17.
all-
They have amended it.
Yes.
They have exercised the power of amendment. You did not object. You did not challenge under 227 then also.
yes, in
You should have challenged it then. They don't kindly do that. But you kept quiet.
Because, my lord, those admissions are on my face of it. But the issue is, my lord, if your lordship will, because in those matters, two points on equity, my lord, not on law, equity on. They have received the amount.
I'm not in 226.
Your lordship may take in. So in these two matters, they have received the money long time back. We have carried out the assessment and we have paid the amount, my lord. Suddenly, after receiving it, at that point of time, contemporaneous materials we would have produced that like.
Why you cannot produce that unless there is a pleading?
Yes, my lord.
Where's your pleading?
The pleading.
Let us apply CPC properly. Where's your pleading?
That have paid the adequate compensation, my lord. That is the adequate compensation.
No. Where's your pleading? When did you pay?
If your lordship will see my written statement, my lord, your lordship, I can't blame my lawyer, my lord, but I have.
Your written statement does not say a single word when you paid.
Page 30, your lordship,
Huh.
may kindly see.
You even went in the extent of saying that they received the surface damage of the complaint were exercised in the year 2015 without any oral or written objection.
Yes, my lord, that
Yes.
we have said so.
And this is, and they filed this petition in 2017.
If your lordship will see kindly paragraph 30, page 34, small Roman 3.
Hmm.
The rate from two onwards and payment was made just in the crop.
Why
and
you are
field.
making this as filed in 2000? This matter is of 2017, it was filed on 19th of December. Which matter is this? This is the name, what is the name of the party? Sahabuddin Loskor.
Yes, sir. The impugn order is at page, my lord. 68, my lord.
So here, you paid on, are you
2000.
sure what you have stated is, these are date of filing,
Yes.
3/5/2017.
Yes, my lord. Yes, sir.
And when did you make the payment?
Payment, your lordship will
Made
find
it
the
in
last.
2015.
Yes, my lord, dates are date.
So it is within 2 years.
In some cases, it is within limitation, my lord.
Then,
In some cases, it is.
and in
within-
other cases, have you mentioned, let us see which case, let us see CRP 36, 36 and a half,
36, 36.
36, sorry. Order was passed on 4th of November 2023. You have filed this on 16/12/2024. Order passed. Of this 4/11/2023. Filing date 16/12/2020. Date of payment is 19. In this petition, you have not enclosed anything. You have not enclosed the petition, nothing.
Yes, my lord.
How do I trick it? In item number, which is this item number? 4.
36 minutes.
Item number 4, you don't have any materials also
We
to
have
say that
judgment
you have made all these things.
demand notice.
So I can't even look into that. And it's a matter under 227. Why should I look into other things?
Permit, we will file additional,
What is this?
30, the date of payment, my lord, but this is not there.
What is this?
This is the money received by parties, my lord. And at next page, my lord. Last line, my lord. Amount received by me in full and final settlement against the said work and assure I shall not raise any
Mr.
further.
Kumar Sudhai, we are going to have our election 2026 next year. There is a likelihood that there would be some election petitions. I will ask the Chief Justice then to allot me a election petition for taking a trial and then take up these matters. You are trying to tender evidence by this way? My goodness. I'm Mr. Counsel, you are how are you going to tender evidence like this? Give it by way like this? Am I going to look into it?
No, my lord.
Then, this is not the way you give it. There are many aspects how you file it. You are under 227, you don't file it in this manner. Then,
Sir,
Sad
we'll
state of
place all these
affairs.
materials, my lord. We'll place, give me one more opportunity to
no,
place
this
all
is
these.
not the- But this is a case of cost. Then.
Your lordship will see that they have given accord and satisfaction and accord and satisfaction.
Is your statement to that effect? That this was filed on so and so, 2014 year, but you have to say the dispute arose when? That is your basic.
Dispute, my lord, yes, your lordship is right. Dispute arose. when
Merely tendering would not be.
Dispute arose when I did the assessment under section 10D of the Telegraph Act, my lord.
No,
Because that is the statutory.
that
order
cannot
which
be
I-
a dispute.
That is because that is the cause of when I assessed the compensation, my lord. I assess the compensation in terms of section 10 D of.
You assess the compensation?
Yes, my lord, because the order says, my
Are
lord,
you saying again, making a statement before this court that you have assessed the compensation?
the section 10 D.
Who assessed the compensation?
Section 10 D, if your lordship will see the Telegraph Act.
Who assesses the compensation?
The act, Telegraph Authority has to assess, and enhancement will go to the, for the.
So
dispute-
in this case, did the Telegraph Authority assess or Power Grid Corporation
The
assess?
Telegraph Authority under the, section.
So
10D.
you have assessed?
Yes.
The compensation?
Yes, my lord.
Okay. And then when did you inform the other side while assessing?
Yes, my lord, because that they say in their.
Did they participate in the process?
They, in fact, my lord.
Let us,
say-
you do one thing.
Yes, my lord.
I'll give you some leverage. We'll have it next week. Produce the records of your assessment being made. See. And if on that day, there is no mention that the others participated, then on that day we
I'll
finish
check,
it
I'll
off.
check. Just see. Because.
Receiving an amount, because
Because that document, if I can show you that they have, the assessment and their sign is also there, sign of the.
when did they sign?
This is 1/4/2014, my lord,
This is your date.
date, my lord. And
You may have given it in 2017 also. There is no signature out there.
this, if you lordship will see the next page, my lord, the page, second page, my lord. Payment was made on 19th January 2015. Money received, your lordship.
Huh?
Money received,
When did you make the payment?
19th January 2015, my lord.
So this is after almost 9 months
Date of assessment.
of the assessment.
Of the date of.
So this was given in 19/1/2015.
Yes, my lord.
The check was given.
Yes.
This is the
After-
case of Mr. Joinul,
Yes, my lord. Item.
Item 4, my lord.
Ah.
CRP 30.
and he filed it on 3/3.
Yes, 3/3/2015.
So why didn't you adduce evidence of this document?
That this should have been placed, my lord.
Then?
That should have been placed, my lord, but your lordship will, I understand that, I don't have answer to this query, my lord, but the fact, only indulgence I am seeking, my lord, is that permit us to lead the, because in one, your lordship's, coordinate bench has taken a view that permission was granted.
Don't worry, I'll take care of that.
You, lordship, no,
Don't worry.
lordship, I know that your lordship, but your lordship will see in the facts of these cases, ultimately your lordship deciding jurisdiction under 2227, my lord. In all these cases, my lord, what has happened, my lord, that the assessment was done after that payment was made, and suddenly.
I think the Supreme Court can help you.
Your lordship can also, well, I can, your lordship, and under 141, your lordship has already accepted that this is a civil proceeding where the issues should have, because I will lead evidence, my lord, only when
When you were asked, you did not.
in one of the matter, any other matters, I don't know, my lord, I have to check, and then only I can make a statement, my lord, that I can say.
In Kamrul Assam, Aslam, Kamrul Islam's case, there you say that you are not going to adduce evidence.
That,
Then you do one thing. I've not called the records for others. You produce the certified copies of the entire order sheet in respect to all these matters on the
Yes,
next. We'll see
Will do.
as to whether you have adduced evidence or not.
Evidence has definitely not been. adduced,
No.
sir. With a
Did
statement-
you say that
Yes,
you
sir.
did not want to adduce?
Yes, that-
If there is a chance that you were not given a proper opportunity, then I can touch it, provided with a cost of 1 lakh each. And if not, then dismiss with a cost of 25,000.
In any case, it's,
1 lakh or 25,000? Produce certified copies. Because the reason why I'm going to impose the cost of 1 lakh is because you have filed after 2 years. In all cases, you are asking this court to reopen after 2 years, which I am not inclined to do so.
Your lordship, ultimately, it is not one, 2 or 3 cases, my lord. There are thousands of, a huge number of cases which I am informed, my lord, of similar nature, my lord.
So therefore, you, in those matters where decisions have not been done, then you go ahead and deduce evidence, file a review, whatever may be. Or till our hope, our new chief justice who is going to come changes my bench. Otherwise, there's no way out. When, next week? Certified copies?
I think some more time, my lord, but if there are 15 matters, my lord, we will need those,
One matter you don't require.
one matter to your lord.
You don't require. You don't require in the case of Kamrul Islam.
No doubt.
That is CRP 41, you don't require. Remaining, you produce the certified copies. Therefore, the learned counsel senior counsel who appears on behalf of the petitioners in the instant batch of petitions had submitted that had the petitioner, had the issues been framed, the petitioners would have adduced evidence. Full stop. Be that as it may, in the present batch of proceedings, one of the matters which are before this court, the records of one of the matters is before this court. That is in CRP number 41 oblique 2025. And this court, upon perusal of the records of Miss PG case number 03 oblique 2018, have duly taken note of that on 29/9/2023, the petitioner submitted that they do not want to adduce evidence. And accordingly, the evidence of the petitioners were closed and the matter was fixed for arguments. Full stop. Taking into account that it is the specific stand of the petitioners in one of the proceedings that the petitioners did not want to adduce evidence. The submission so made that if the issues were framed, the petitioners would have adduced evidence is completely misconceived. Be that as it may, this court, however, gives an opportunity to the petitioners to place before this court the certified copies of the orders passed in the other proceedings, which are being challenged in the instant by way of the present batch of applications. To full stop. List this matter again on that day we finish it off, huh?
Lord,
10th of
may I
June.
May I
10th
request
of
for
June.
after vacation, my lord?
No, 10th of June.
My
No,
friend-
these matters you can't escape. These matters are tagged with me. 10th of June.
Lordship, may have it after.
Mr. Kumar, kindly see the second one. The second. Seeking adjournment of listed matter on behalf of senior employee is not permitted. So don't make that. If you are not,
My friend.
he may ask for,
11th, Lord, he will be there on.
he will be there.
My lord,
11th, not 11th, 10th. 11.
Item 16,
I took
Which one?
certified copy of the audit.
No, those documents you can produce it because I have given you the leave. Certificate, not this. This I am not going to look into.
Grateful.
Take on file, huh? Mr. Kumar, if you can just point out, this matter is gone. 11:41 is finished. The other matters, if there was an opportunity which you lacked, I will remand,
I get.
but 1 lakh. Yes, what it is? Such a fat petition. What are you challenging?
So I'm challenging you, if you not are, lordship will file case 216 or what?
Huh?
216,
Page?
216, 216.
How much was the delay?
The delay was 100.
Section 5? For what?
143 days was delay.
Huh?
143 days delay was there.
The case is under section 5 against the petitioner. The order passed by this court. Huh? You are challenging an order of 2/3/2020 today.
Because the time you lost it, the time was passed from the March 15th, there's a lockdown was started, the loss of.
Huh? No, you are challenging under what provision? 227, how?
They did 115.
Why you are challenging after 5 years here?
See, because the person who had the land measuring 4 kata, your lordship, because of the impune eviction, the execution of the decree, your lordship, the entire property has been taken away by the, in connection with the title suit, your lordship, where I was neither a party of the proceeding nor the.
Everything is understood. The impune order is dated 2/3/2020. Why have you approached after 5 years here?
Lordship, because the impune order was issued on 2/3/2023, in the meantime, lockdown was started, your lordship, the business of the person of the.
The period ended on 28/2/2022.
22. Thereafter,
Thereafter, explain why you have taken so much.
Lordship, the financial condition of the person because of the taken away, where is the business of the person was dealing with, I have mentioned in para 13 of my petition, your lordship.
You cannot come after such a long. Cannot come like this. And where is the High Court's order?
Lordship will find page,
Huh?
page 176, your lordship.
You did not take the advantage also.
Lordship, I have filed.
You should have got an order, the period has to be removed.
Lordship, that is why after the.
See, for getting the benefit under 14, there has to be an observation by the court that they were proceeding bona fide. And as such, this period has to be taken out. If this is not there, then it's a simple case of withdrawal. Section 14 benefit you only get if it is there. So no case. And after 5 years, nothing wrong. So dismiss. Dismiss.
Lordship, additional effect may be allowed to file also with the proper explanation, or lordship, why I have not, there is a delay of.
No, you can't help it. First of all, you have moved after 5 years. That is one aspect. Second is, most pertinent, is that you don't get the benefit under 14. The court is right.
Lordship, this petition was filed under section 5 as well as the limitation of, as well as.
You
section
don't
14
get the benefit of 14. Taking into account there is no observation by the court while granting you the leave. Then there are many judgments of the Supreme Court also in that regard.
Possible date will fix, lordship, I will satisfy, lordship.
Hello. When do you want the dismissal?
Lordship, next week, any day next week.
Pick a date. Let's take unlucky 13. Okay. But list the matter at the request of the petitioner, list the matter on 13th of June.
Seventeen.
Seven, it is the order of the railway claim tribunals, that is page 41. I have filed an application for, because after the death of my son, the amount was fixed deposited. And out of 4 lakhs each, 1 lakhs and 1 lakhs was given. Then I filed a miscase and for a withdrawal of the entire amount, because I am the 65 years old and my wife is 62 years old. And there's none to look after us. And there's a loan in the market, my lord, since 22 onwards, because I'm the key labor, my lord. So at least, my lord, I'll pray for a one release of the one fixed deposit, my lord, so that I can circumstance those difficulties. My lord. Instead of 2, I'll pray for one release, my lord. That is my limited.
How much is the award?
My lord,
How much was the award?
the award was 4 lakhs each, my lord. 8 lakhs. Okay.
8 lakhs. And how much you got the amount recently?
1 lakhs each, my lord.
2,83,000.
with interest they have given.
And you require further amount, why?
Because my lord, there's a depth in the market, my lord. This depth in the market, loan in the market, and also for my treatment. That I have paid stated in my paragraph and last paragraph of the petition, my lord. Paragraph 8, my lord. Because there's none to look after us, man.
Huh?
There's none to look after us. One son is there, he's a vagabond. And he's the tea garden, but he is it about 65 years.
What do you do?
Tea garden labor, my lord.
You're tea garden labor.
Labor. Only 65 years old as on today. Today, he is a 65 years, my lord, at the time of filing. So he wants some money so that he can repay and construct his house. I stated in paragraph 8, my lord. And I also feel that the amount in the wife's account may be fixed, my lord. And
So your amount should be released.
released, my husband. There's no more money.
We allow it?
There is, I think there is no.
No, it has been done in the benefit. Why this is being done? Not for those persons to hear, because at this time, what happens, the money is actually goes to some other persons.
That's true.
That is
That
the
is the
reason
second-
why, in very good language, they say that it is for the benefit of the others. Everybody knows.
So I say, well,
Okay.
only one live. Only one. For husband, wife may be intact. That I'll say. Because tea garden labor, your lordship also knows the nature.
Heard Mr. K. Bachcharji, the learned counsel. Now, Mr. A. Gayan, who appears on behalf of the respondent numbers. All the respondents? All the respondents. The present petition has been filed invoking the supervisory jurisdiction of this court, challenging the order dated 8/4/2025 passed by the Railway Claims Tribunal Guwahati bench, whereby the applications filed by the petitioner seeking release of the remaining amount, which is kept in the fixed deposit taking into account that the petitioner is 65 years of age and requires the said amount for the purpose of his medical treatment and also for making a house or constructing a house. This application was rejected on the ground that the petitioner as well as his wife have received an amount of rupees 2,83,000 recently. When did you receive?
My lord, I received on, my lord,
There is of 8/4.
on 8/4, my
8/4?
2000, 2005.
25.
Then why do you
8/4.
require that?
I have received on 8/4/2025, my lord. This 2038. But I need the money for this because there's a loan in the market for from 22 to 25 years, 2025, my lord. I have to borrow the money for conducting the case and other thing, my lord, because there was no livelihood for me because my son was the only livelihood. He was a driver. So he is giving the money.
So what did you do with this 2,83,000?
My lord, I have to clear the dues, my lord, loan amount.
You have taken loan
Yes,
in
sir.
writing.
Yes, no, he got it, my lord, there's no thing is only oral loan amount. You give me some money, you give me.
Not satisfied.
That's it.
I'm also not satisfied. Not satisfied.
Received amount on 8/4/2025, few days later.
You received on 8/4/2025.
Yes.
And on that day, again, you file another petition.
No, after that day, my lord, if I'm not wrong.
Now, when did you receive to 8,23,000?
8/4, my lord, 8/4.
And on that day, the impugn order is also passed.
Pass.
Means you want the release of the entire.
No, my lord. Earlier, we have received the amount, fixed deposit was given. We have received the amount, thereafter we filed this petition for releasing.
So what is your ailment?
My lord, old age element, my lord. That is as stated in paragraph 8, my lord. Old age, my lord, because he is suffering from certain diseases like my lord, weakness and all these are there. I've stated it there, my lord.
What witness? You have stated no, what is the documents?
Documents I have not annexed, my lord. Because those labor people, what documents.
Okay, provide the names from whom you have taken the loans. Provide the
I will,
names
I can explain, my lord.
along with the medical.
as well as the medical effort.
Yes.
Let this matter be listed again on 16th of June 2025. In the meantime, the petitioner is directed to file an additional affidavit bringing on record the persons in whose favor, who again, from whom he had taken loan and how much and from when,
So the medical report
as well as the medical documents
for his.
that
treatment.
he is requiring any further treatment. This court have directed, taking into account that on 8/4/2025, the petitioner have received already an amount of rupees 2,83,000 and odd, and further seeks release of another 3 lakhs. It's the matter.
Yes, I am not advocate on record, my. My lord, it's,
What are you challenging?
my junior, my lord, mention in the mention our, my lord.
What are you
Because
challenging?
because advocate on record is out of station. So, my lord, I pay that matter may be adjourned for a day, my lord. It is the first time it is listed, my lord. No stay night of this. Only for the first time it is listed. It may be taken on Monday, no problem. my lord.
So licensee, my lord, there, no, nothing is there, my lord. If you also see the prior in the plaint, my lord, that page 21.
This is appeal filed under what provision?
My lord, what happened? it
Public
is-
premises.
I have filed a
No,
title
no,
suit, my
public
lord.
premises, my lord.
This
my
is
lord,
under what?
Licensee,
Injunction.
injunction.
Injunction, my lord. What
Injunction.
happened, my lord? I
My lord,
filed a
this
title
will be,
suit.
my lord, done.
My lord, it is a matter of
The suit
nineteen
itself is
eighty-seven.
not mentioned.
It's matter of 1987. I don't want to argue, my lord, because, my lord, I am not with grief. 1987, my lord, I was permitted to run a canteen. I am a person as at about 80 years. What happened, my lord? After, my
Now,
lord,
what is your age?
80.
What are you going to do, ma?
My lord, that is my source of income, my lord. I am to survive, my lord. When I will die, my lord, I will die. Because, my lord, on their permission, my lord.
You
I-
say 80 years, but when the suit was filed, it was 60.
My lord, it was
2017, the suit was filed, it was 60.
17, another,
8 years is 68, not 80.
my lord, maybe, my lord, 60.
My lord,
Say, my lord, I am 68 years. Now what happened, my lord, from 87 onwards, my lord, I am running the tea shop on their permission. And now what happened, my lord, up to 16, my lord, that was renewed. And after that, it is directed that you vacate these premises. And I filed a title suit. And this title suit, my lord, I filed injunction. Injunction was rejected. Then I filed an appeal before your lordship. Then your lordship, due to raising of pecuniary jurisdiction, referred to district judge, my lord. And when your lordship referred it, at that time, my lord, status quo was directed to be maintained. And thereafter, the appeal was heard, my lord, and this impugned order was passed. Anyhow, my lord, the advocate on record will argue, my lord, on Monday, my lord. It will be taken on Monday.
They've been submitted that on, submitted that
my lord,
that Mr. K.U. Ahmed, the counsel who
Out
represents
of
the
station.
petitioner, who represents the petitioner is out of town. So this matter again
my
on.
lord, can it be on, my lord, Wednesday, my lord? Please? Because I have many matters.
Any day, my lord, I have no objection.
Wednesday, my lord.
Court. 4th of June 2025. Mr. G. N. Sarvan accepted by Sarvan and G. N. Sarvan.
Oblige your lordship.
19,
See the government.
Can
Yes,
you
what is it?
kindly pass over the letter for the
Why?
day? I have no brief on as of day today.
Hmm?
But the fact is that the one title suit was decreed, judgment and decree was passed, ex-parte. Then ex-parte order was challenged, ex-parte vacating petition was filed. In the meantime, title execution has been going on. In that title execution, a petition was filed for stay,
Of the
title
execution.
petition. But wrong provision has been put it. 151 CPC only written down. That is why the state petition was rejected. So nothing has been wrong, but I filed this petition only giving a liberty, lordship can may allow me to file a fresh stay petition under proper provision. That is only simple, my humble prayer.
You're challenging 12/1/2023 order now.
23, not 23 order, I think.
What is the order you are challenging?
The last stay vacating,
Huh?
stay order, last
12/1/2023.
12/1/2023.
23. You have challenged an order of 12/1/2023 in the year 2025 for not granting you a stay in an execution proceeding. Please take in the benefit. What else is required here? If nothing has happened till now,
Till now, nothing. has
means
happened.
nothing is going to happen.
How about the-
12/1/2023, you filed a petition saying that you have filed an application under Order 9, Rule 13 for setting aside of the judgment and award dated so and so.
This is
And as
pending.
such, kindly stay my execution proceedings. That was rejected on 12/1/2023. More than 2 years after you are filing this petition, meaning thereby you have, that execution have not proceeded.
Execution is not yet proceeding.
Then why you are
No, no,
filing this?
execution is going on.
How is it going on?
Stay is not there.
Huh? No case. Case for dismissal right away. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. First of this, the supervisory jurisdiction of this court have been invoked, challenging an order dated 12/1/2023, passed by the learned court of the Civil Judge Number 2, Kachar at Silchar, whereby an application filed under 151 for stay of the execution of the ex-parte decree dated 2018, passed in title suit number 98/2018, till the disposal of the application filed for setting aside the ex-parte, that is Ms. J case number 50/2022, was rejected. First, this court finds it very pertinent to take note of that an order dated 12/1/2023, by which a stay was sought to the execution proceedings, is being assailed before this court on 3/5/2025. After 2 years, 4 months. Full stop. And the learned counsel appearing on behalf of the petitioner submits that till date, the execution proceedings have not culminated. under such circumstances, the challenging of the order dated 12/1/2023, after 2.5, almost 2 years, 4 months, to clearly go to show that the petitioner have all along availed the benefits of the execution proceedings having not been culminated. What has happened to the setting aside?
It is going on. It was not yet disposed.
It is also surprising to take note of that the application filed under Order 9 Rule 13 is also pending
Pending.
before the same court. First of all, I have not stated what are the reasons why after 2 years, 4 months, the instant proceedings have been filed. Challenging an order dated 12/1/2023. Considering the above, this court finds no ground to exercise the supervisory jurisdiction for which the petition stands dismissed. Thing has happened. You should be
20.
happy. You could stall for 2 years. I think now the executing courts are getting here because of the Supreme Court judgment. They have to finish off.
Of course,
Yes, what is this?
my lord. In this matter, my lord, the applicant bank has received one recovery certificate from the debt recovery tribunal.
What is the order you are challenging?
My lord, that is in the page number.
Huh?
Order recovery officer stay the execution proceeding just because the bank has filed one title application, title suit in case 2, in which the Schedule C property, there is the 5 property. Out of 5 property, 1 property has been sold by the borrower to the third party.
Hmm.
That sale deed has been challenged.
So what are you challenging?
My lord, the order.
Which order?
28/2/2025, my lord. Page number 106.
10?
6. The operative part in the page number, my lord. 110, my lord. May I read?
This is passed by whom?
It is passed by the recovery officer, debt recovery. Fair number 6B onwards, my lord.
This is passed by the recovery officer.
Recovery officer.
Why you are not moving the presiding officer?
My lord, there is,
There is a provision out there. The
the-
Debt Recovery Act. Why should we exercise jurisdiction?
my lord, in this particular matter, my lord, earlier also, this honorable court has passed one order.
Well, earlier is different. This court is different.
This court has,
No, first and foremost, the question is why you have not gone there.
my lord,
Debt Recovery Act, where is the recovery of debt? There is a provision, specific
there is a
provision.
provision, my lord, there's rule 31. There is a provision for filing of appeal before the debt recovery presiding officer, DRT.
No, before the presiding officer.
Yes,
you
before
are
the
not going
presiding
there?
officer, debt recovery tribunal, in case there is any order against. But in this case, he has used his judicial excessively, my lord. And but particularly in the similar matter, in the similar terms, my lord, this honorable court, particularly this honorable court has passed one
Appeal,
order.
Section 30, notwithstanding anything contained in
madam.
section, any person aggrieved by an order of the recovery made under this act may within 30 days from the date on which, on receipt of the appeal, the tribunal may give an opportunity to the appellant to be heard after being deemed fit and set aside the order of the tribunal in the case of so and so. Why you are not going there? Section 30 of the recovery of debt tribunal?
Well, my lord, but kindly see one.
No, 227 does not arise.
My lord, only 1 second, my lord, page number 90, 96, 97, ma'am. Page number 96, 97, 94, 5 onwards, ma'am. In the same matter, ma'am.
in the same matter, madam, the grower approached this honorable court. In this, on 24/4/2024, this honorable court has decided this matter that page number 97, para number 5, taking into account the above development, more particularly the communication related, this court is of opinion that there is no hindrance of the part of the recovery officer, the applicable to proceed with the recovery proceeding according to the law. So accordingly, we proceeded.
I said because of the surface proceedings.
Madam.
I remember now this case.
Yes, yes,
Now
yes, yes.
there were two proceedings.
Yes, sir.
One, they were proceeding against under the surface side, under that again by the recovery officer
Doctrine of elections.
election.
Yes,
So
sir.
therefore, I asked the recovery, Mr. Doctor was appearing as
Yes,
Doctor
yes,
Senior
yes.
Counsel. So when he was appearing, I asked him that what would you like to go? Would you go with the surface side or under the recovery? So he said that, okay, we are going ahead. So I said, you go ahead, drop as you are dropping the surface side, because there was also a letter also being produced before this court. By the detailed order inquired whether the respondent further wishes to proceed with the proceedings under the surface side or before the recovery year. Pursuant thereto, affidavits have been filed by year, thereby electing to proceed before the death.
Yes, madam.
So you go ahead. Now, this order which is being passed is because of a pendency of an appeal or some suit. This is the order. This has nothing to do with that proceeding.
No, madam. Madam, in this case also.
So the question is,
senior
the
counsel is
simple,
also,
no, mister, the simple question is why you are not going under section 30?
Can I satisfy on the next?
Huh?
Can I satisfy on the next statement?
Yes. No, now,
Mhm.
there has been a lot of matters being asked to satisfy on the
Madam, in
next.
this matter, Mr. Senior counsel is also there. madam.
He's not there. Number two,
Yeah, that's why I'm. Madam,
senior counsel, no
kindly fix
adjournments.
on Monday. Kindly fix on Monday. No, because of the recovery. Kindly fix on Monday.
Huh?
Kindly fix on Monday.
But you don't get the benefit of limitation.
I will.
For, limitation, because you have to move under 30 days. So because of the pendency out here, you don't expect. When do you want it? Monday? Wednesday?
When is-
The learned counsel appearing on behalf of the appellant petitioner being not prepared, this will matter again on Wednesday.
Rip.
21,
Yes, Mr. Zakia.
Lordship, matter related to that limitation, Lordship, that is filed after 6 months, Lordship.
Huh?
After 6 months, Lordship, coming into effect of new act, Lordship, 1/4/22.
When did I fix those matters? Mr.
Somewhere
Kulita is
I
there.
have 13th,
Huh?
13th June, I think, Lordship.
13 June, huh? So I take along with this. Issue notice, making it returnable on. Why do we need the notice? Or we can only have the notice upon the petitioner, why others not necessary? Issue notice, making it returnable upon the respondent number 1. Returnable on 13th of June 2025. Steps be taken upon the said respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next stage. Full stop. The petitioner herein have assailed the order dated 14/5/2024, whereby the delay in filing the claim proceedings by 47 days was condoned by the learned tribunal, learned member Motor Accidents Claims Tribunal, in Miss Case number 34/2023, arising out of MAC case number 149/2024. Post of the learned counsel appearing on behalf of the petitioner has submitted that in view of the provisions of section 166(3) (3) of the Motor Vehicles Act 1988, which have been brought on into effect with effect from brought into effect from 1/4/2022. The proceedings could not have been filed beyond the period of 6 months from the date of the accident, which was in the instant case on 12/9/2022. So taking into account that this court is taking up similar issues on 13th of June 2025, full stop. This court further stays the further proceedings of MAC case number so and so. One kiba asil no?
149/24.
149/2024 pending before the court of the member MACT Nagaon till the next date. First of list the instant proceedings along with the CRPIO number, anybody? 100 asil na? You ask that number.
111, I think.
111 na? 111/2025. I remember something like 100 or
111/24.
24 na?
22.
It's matter of the adjunct, my lord.
Why?
For next, Mr. RD is appearing in this case, my lord.
Who?
RD, Rubjit Day, my lord. So he is unable to appear today, my lord, because of portal looking officer area, my lord. He is unable to appear today, my lord, because of portal looking.
Oh, video conferencing? This is a
Yes.
case for dismissal, right away. What is the stage of amendment?
There is a amendment, my lord. Amendments are allowed.
What is the stage on which the amendment application was filed?
Actually, my lord, I don't have brief. my lord. There's-
You are without the brief, so I
Yes.
don't expect. When a person appears without the brief, I don't recognize that he is there.
I am on behalf of my lord,
I don't know, none appears, so we dismiss for default. Oh. Amendment, this is. The court had recently allowed it is at the stage of pleadings. Then what is wrong? Hello, we
Okay.
dismiss it on Monday.
Monday, my lord.
Okay, list the matter on Monday,
Obliged.
taking into account that the counsel appearing on behalf of the petitioner did not have the brief when the matter is called up.
23.
Yes, Mr. Sharma.
May it please your lordship. My lord, this petitioner before your lordship is the judgment for lordship. In order. Lordship, Page 36 lordship.
Stay. There's another suit pending.
Lordship.
Huh? What is wrong with the order?
Lordship, this petitioner has filed two applications, lordships, for stay of execution, lordships. And both the petitions turned down lordships by order dated 11/3/25 lordships. And accordingly, lordships, he has approached the Procedural Court lordship. This decree holder, he has submitted the amount rupees 6,50,000, and the judgment debtor has not collected the same lordship. On the other hand, lordships, his judgment debtor, as he is a tenant lordships, he wanted to deposit the rental amount, and it was refused lordships. And accordingly,
Judgment debtor wanted to?
wanted to deposit the rental amount lordships,
Ah.
and it was refused lordships. Now lordship subsequently, as the execution case, it was filed in 2018 lordships. One of the judgment debtor, Shivnath Day lordships, he expired on 2015. Lordships, as he expired on 2015, execution case filed in 2018. And accordingly, lordship, this application was filed for setting aside the execution order, lordships. But this petition was rejected, lordships.
Who made that?
And accordingly, the application, accordingly, the or petitioner has approached the Procedural Court against the order dated 11/3/2025.
Mr. Your petition, this petition is to be dismissed on the ground that the law very well says that when a decree is being passed, it shall apply to all the legal representatives, 146. You don't need to implead them. It is, on the face of it, it comes in, except a suit for permanent, when it's a case of execution of a decree for permanent injunction.
Lordship is meanwhile on JD lordship, judgment debtor expired lordships. His legal years are there, and those legal years are not made party.
You go there, appear. When a judgment and decree is being passed, by virtue of section 146, it applies to everybody. In the case when the suit stage is at the suit, then the question is different. Prior to the judgment, prior to the hearing, if somebody dies, then the suit may abate. But after the judgment, after the judgment hearing is complete and the judgment is reserved, if anybody dies, immaterial, not necessary to implead or anything. Execution proceedings can be proceeded against anybody except an execution proceedings under Order 21, Rule 32. That cannot be because of the fact that it requires a precondition that there is a willful, they knew about the judgment and they have failed. So that is a suit for permanent injunction. The decree for permanent injunction cannot be done without impleading them. But otherwise, it can be done, rightly so. Then, what is the next case? Why do you want to stay under Order 21, Rule 26?
Lordship, because lordship, this
Application of impleadment is not there.
not.
No case. So the RSA number 222/2024 is pending.
Lordships,
It's pending before this court.
Lordships.
Is there a stay?
Stay is not there.
So then, why you are filing these type of applications there? You have to get a stay there, here. Then you move, where is that matter? Title 222.
RSA Lordships
Substantial question of law formulated.
was formulated Lordships, but in a separate case, then Lordships Honorable Court directed to bring it according the RSA Lordship. And accordingly, Lordship, one miscase was filed. And that miscase, it was disposed of on 7/4/25 Lordships. And accordingly, Lordships, this RSA, amendment of RSA is yet to be submitted before the Honorable Court. As
So
of
you
now,
have to get an order there. If you want of a stay, you have to get an order there. You can't move on order 21 rule 26 there. Because it is in respect to the same suit.
Same suit.
Because they hear these people are, the judges are under constant pressure because of the judgment of the Supreme Court. That is the big problem, Mr. Shan. One has to also appreciate one thing, that there has been a direction in this judgment in Periamal, that you have to dispose of the execution proceedings within 6 months. And not only, it doesn't stop there. It further says that if he's not, the presiding officer will be held responsible and further actions will be taken on the service side, which is a very serious thing for them. So they are under compulsion. I won't comment on the Supreme Court judgment on that aspect, but the aspect is they are under compulsion. They have to finish it off. So you have to get a stay there. Not here. They can't, they would never do that. You file an application in that case. You want, if you want, I can take it up next week. The other one,
RSA Lordship.
if you have filed an IA.
Lordship, next week Lordships. Next week Lordships,
You do one thing, you give a mention memo
Lordships,
to them. We'll take it up on Wednesday. RSA,
RSA.
you withdraw this. If I dismiss, again the problem arises there.
Lordship, this RSA, amendment of RSA, yet to be submitted, Lordship. Matter,
There cannot be an amendment of the RSA. RSA only includes the substantial question of law. In our case, there are many cases where they are there, but where if the substantial question of law has already been formulated by the court, then the question will arise as regards stay.
as on now, it is not permanent.
There the problem arises. And the substantial question of law and the second appeal, if comes back to me again, another big problem. It will be dismissed. So getting a stay here is a better option. No case. Chalo. Heard Mr. R. Sharma, dispose it of. Heard Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner. Full stop. The petitioner herein have invoked the supervisory jurisdiction of the court, challenging the order dated 11/3/2025, passed in petition number the common order dated 11/3/2025, passed in petition number 56/2025 and 85/2025, whereby the learned court of the Civil Judge Junior Division Nazira, Sipsagar, Nazira had rejected both the applications. First, it is the instant proceedings is being taken up at the motion stage for disposal. First, next. For the purpose of It is seen from the materials on record that the petition number 56/2025 was filed by the petitioner stating inter alia that Shivanath De, alias Shibu De, who was one of the defendants judgment debtors in the suit in the execution proceedings, expired on 23/6/2018. And a possessory warrant was issued for delivery or possession of the decretal land against the dead person. And therefore, sought for stay of the execution of the possessory warrant for delivery or possession of the decretal land until substitution of the legal heirs of the judgment debtor, number 4, is carried out. This court finds at this stage relevant to take note of the provisions of section 146 of the Code of Civil Procedure 1908, which categorically stipulates that where any proceedings may be taken or application made by or against any person, then the proceedings may be taken or application may be made by or against any person claiming under him. Full stop. Consequently, as the said Sibu De, as that the said Sibu De, alias Sivnath De, was alive at the time when the judgment and decree was passed by the learned trial court. This court finds no illegality in the impugned order insofar as proceeding against the legal representatives of late Sivanath De, alias Sibu De. Full stop. It is further seen that the petition number 85/2025 was filed before the learned trial court under order 21/26, seeking stay of the execution on the ground that the appeal, being RSA number 222/2024, is pending before the court. Full stop. The learned trial court, the learned executing court, no, full stop, pending before this court. Full stop. This court put a pointed question upon Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, as to whether any substantial question of law have been formulated in the said appeal, and thereby admitting the said appeal. The learned counsel submitted that the appeal is yet to be admitted by formulating a substantial question of law. He further submitted that in the said appeal there is an application filed for stay of the execution, but without the appeal being admitted, but without the substantial question being formulated in the appeal, the said application cannot be taken. And as such, the application was filed under Order 21, Rule 26. First, this court is of the opinion that mere filing of an appeal would not amount to stay of the execution of the judgment and decree, as is the mandate under Order 41, Rule 5 of the Code. Further to that, it is also well settled that without formulating a substantial question of law, this court would not have the jurisdiction to pass any order of stay. Of the execution. Full stop. This court further have duly taken note of the judgment of the Supreme Court relied upon by the learned executing court, that is in the case of Periamal dead through LRs and others versus B. Rajamani and another, reported in so and so, wherein the Supreme Court had made certain observations as regards completion of the execution proceedings. Considering the above, this court is of the opinion that the reasons so assigned for rejecting the application under Order 21, Rule 26, on the ground that the appeal has been filed, a second appeal is pending before this court, filed before this court, does not call for any interference. First, accordingly, the instant petition being without any merit, for which the instant petition stands dismissed. Before parting with the record, this court, however, observes that the order so passed herein is only in relation to the order dated 11/3/2025, passed in title execution case number 1/2028. The same shall, however, not impact the merits in RSA number 222/2024, as well as any application filed seeking stay of the judgment and decree.
24.
So, Mr. Sheikh, you are ready with this matter?
My lord. Your lordship will turn to page 107, impugn order.
The amendment allowed.
Yes. So, my lord, what happened? It is the third amendment.
What is the stage?
PW 1, 2, 3, 4 in SIP has been submitted. PW 1 and 2 cross-examined.
Then they file this.
They filed this. And it is to be mentioned here, my lord, it is the third amendment petition. Because, my lord, first it was amended petition earlier filed, and thereafter, my lord, again.
Where is the
another
petition
amendment.
seeking amendment?
My lord, seeking amendment petition, my lord. Your lordship will turn to page 95.
Mister, this is very simple. This is not, only the number is changed.
Your lordship.
But
would
only
please
thing
to
is-
see. Actually,
But only thing is, I'll issue a notice only for the purpose of getting you some cost. That's all. I'll allow, I would dismiss your petition, but I'll change that.
but one thing, your lordship, what ground I have taken, my lord, what they prayed, my lord. My first ground is this, they want to amend para one of the amended plan in 5 after Khotian number 91 shall be replaced by 19 so and so. But in para one, my lord, your lordship would be pleased to see that is not there. That is my ground. Anyhow, my lord, let notice go. And till then, my lord, this proceeding may be stayed. Otherwise, court proceeding will continue. Cross-examination will be there. And in the stage of cross-examination of 3 and 4, my lord, this has come.
Now, another interesting thing is in the deposition of all the witnesses in para, so they are also seeking amendment of the deposition.
Deposition. And deposition, and another thing is this, my lord, what they prayed for. If we go to the plaint, my lord, amended plaint, that is not there. It is completely perverse on record, my.
Sir,
That your lordship will look into,
word
but
by
further proceeding may be
petitions.
stayed.
Issue notice making it returnable on how many defendants?
Defendants are there, my lord. Defendants, I'm giving, my lord.
Who is the plaintiff? How many plaintiffs are there? All are plaintiffs.
Large number of plaintiffs, my lord, but
Issue notice making
here
it
your
returnable on
lordship-
23rd of
11, my lord.
take
ele-
steps.
11
23rd of December.
11
23rd of,
respondents.
June 2025. Steps be taken upon the respondent numbers 1 to 11 by way of registered as well as usual. Registered.
By registered, my lord.
Registered. So in addition to that, the petitioner is also directed to take steps. Petitioners are also directed to take steps by way of the state, routed through the registry of this court and file an affidavit of service on or before the next
Alright.
date. Full stop. The petitioner herein have assailed the order dated 2012-2024. Why you are assailing today?
My lord.
Now,
No, my lord, it is within time, my lord. No problem.
what is with
Because there was some problem.
what is
there
with
was
you
some-
file it
I
on
filed-
Mr. Counsel, you file it on 16/5. Have they filed the amended plaint?
Sorry, my lord.
Have they filed the amended plaint? 100%.
Yes, my lord.
Then why should we entertain this?
Amended plan.
They've already filed. Why have you challenged on 16/5/2025?
1 minute, my lord. Let me clarify. Amended plan is not filed, my lord.
Why, well, what is your basis you are saying?
Yes, my lord, amended plain, my lord, amended, miss case only 224. We have filed objection, my lord. Objection at page 96, thereafter impugn order, my lord. No
Impugn
amended-
order was passed
amended-
on 2012-2024. Thereafter, there is no mention why you have moved this court so late.
My lord, amended plain, whether filed or not, my lord, I am not clear. That position I am to clarify.
No, if it is filed, there is no point. challenge. You will be entitled for further cross-examination. That's all. Let them do. They only want to change that it should be 91 to 99.
But that is not in the amended plan, my lord. That is in para one. Para
Whether
one,
it
there
is
is,
there
there
or
is,
not,
there
they
is
have,
no mention of that.
whatever, you object to that,
My lord.
object there.
Hello.
When that paragraph is not there.
Yes, my lord. No, my lord, when amendment is allowed, where is this scope? Your lordship would be pleased to see the amended plan, my lord. Amended plan, my lord, your lordship.
No case. We dismiss it.
My lord, your lordship just said.
Mr.
see
Sheikh,
Page 18, my lord.
no, Mr. Sheikh, I'm dismissing it.
No, my lord, page 18, there is no mention something. Your lordship will turn to page 18, my lord. Page 18. Your lordship would be pleased to see
Oh, yeah, they
Yeah.
made it, see.
para one,
No, this correction has been done.
my lord,
Page C, page 20.
page 20, my lord. Yes,
See,
my
the correction, you are saying that. Kindly see 91 is there. Page 20, paragraph 2, 91.
my lord.
99, they have cut it.
My lord, but your lordship would be pleased to go to Miss case
I am
number
not going to look
two
into.
43, my lord. No, my lord, in 243, they want to amend.
No,
para
Mr.
one, my lord.
Sheikh, this is not a case. You fight it out there. Heard Mr. M.A. Sheikh, the learned counsel appearing on behalf of the petitioner. The present petition has been filed challenging an order dated 20/12/2025 for passed in. Means the case number 243/2024 arising out of title suit number 246/2013, whereby the amendment sought for was allowed. Full stop. It is relevant to take note of that though the order was passed on 2012/2024, the instant proceedings have been filed on 16/5/2025. After more than almost 6 months, just prior to after almost 6 months. There is no explanation why the petitioners could not approach this court earlier. Although there is no period of limitation provided in a proceedings under Article 2 to 7 of the Constitution. But then also, as the provisions, as the power under Article 2 to 7 of the Constitution is a supervisory power, there has to be an explanation as to why the proceedings have been filed so belatedly in respect to an ongoing suit of the year 2013. On this ground alone, the instant proceedings is required to be dismissed. This court further takes note of that the amendment which was sought for in the plaint was that in paragraph 1 of the amended plaint, the word Khatian was mentioned as Khatian number 91, which should be replaced by Khatian number 91. And further, the word Khatian number 70 in paragraph should be replaced by the word Khatian number 96. The learned trial court, taking into account that the said amendment would be necessary for the proper adjudication of the dispute, and only in respect and it appeared that the same was only certain typographical errors allowed the said amendment by giving detailed reasons. Taking into account that the said amendment has been allowed, this court would not like to exercise its supervisory jurisdiction. This court, however, finds it, before parting with the record, this court, however, finds it relevant to observe that by the impugned order, the examination in chief of PW
1, 2, 3, 4.
1, 2, 3, 4
Page 55 to 83.
was also sought for. It is not known as to whether and it appears from the impugned order dated 2012-2024 that the reliefs have been already, if relief is been granted in respect to the prayer made in the entire petition. First, taking into account that Order 6 Rule 17 only postulates amendment of the pleadings, the amendment so allowed would only be restricted to the amendment of the plaint, which, as stated herein above, this court is not inclined to interfere. However, taking into account the amending being allowed in the evidence examination in chief of all the witnesses in the examination chief on affidavit filed of all the witnesses, it is the opinion of this court that the petitioners herein, who are the opposite parties, should be given an opportunity to cross-examine again the witnesses in view of the amendment made to their deposition. Are the cross-examination over?
Cross-examination only 1 and 2 over.
Others not over?
No.
Accordingly, this court observes and directs that the learned trial court, taking into account the above observation, shall pass appropriate orders before the appropriate orders, so that the petitioners herein, who are the respondents, defendants in the suit, is given an adequate opportunity to cross-examine the witnesses who have been already cross-examined only on this aspect of which amendment had been allowed in the deposition.
Obliged.
Twenty-five.
Agreed by Madam. Order dated 11/4, page 69.
Page
Page 69, in the case
69.
69.
Huh?
69.
Appellant and respondent today is fixed for judgment. However, while preparing the judgment in this, I found that there are anomalies with regard to the periodic patta number 7 by EM. In order to clarify the extent so and so is required to be examined in so and so. Yes. What is wrong?
My lord already in practice, because my lord already statement recorded. So my lord, this petition has become infractuous.
Done. Infractious. Anyway, the order is right because of the fact that this court, the appellate court, have the jurisdiction.
My lord, our apprehension that my lord, the defendant side not execute any document.
Understood. When the court finds, that is the judgment in Union of India versus Ibrahim. In fact, what this court did should have been done by all courts, which is not being done.
Yes, yes.
And I keep on passing orders to the referee. This appears to be the right approach. That at the time of delivery of judgment, if you find, then you will have a right to cross.
My lord, I'm afraid of that to make it clear. What we,
Huh?
my lord, right to, my lord, cross, because we could not cross.
Now the attorney is required to be examined. Now, if he is witnesses, then file an application for cross. File an application for cross before that court, the court will permit. Because if you are taking additional evidence, you have a right to cross. The learned counsel had Mr. Chauhan, the learned counsel appearing on behalf of the petitioner, who submits that as pursuant to the order dated 11/4/2025, the Eastern Settlement Officer, Puloni Circle, have already been examined as a court witness, comma, nothing further remains in the instant petition. He, however, submits that the petitioner should be granted an opportunity to cross-examine the Eastern Settlement Officer if Huh?
They are called AR, Assistant Revenue.
Eastern Revenue Officer. We say that the witness may be permitted to cross-examine the court witness if any statements are made which goes against the interest of the petitioner. Full stop. It is the opinion of this court that if the petitioner wants to cross-examine the court witness, comma, an application is required to be filed before the said court. Full stop. Taking into the account that the statement of the assistant of the Assistant Settlement Officer Puloni Circle have already been recorded. Nothing further remains in the instant proceedings. Full stop. Be that as it may, the petitioner would be at liberty to file an application for cross-examination of the said court witness. Full stop. The learned court of the Civil Judge, Senior Division, Karbi Anglong shall duly consider the same. Above the petition. Your appeal is allowed, huh?
Obliged.
Supplementary item 56 fixed at 2 p.m.
This already covered case by the decision passed by the Honorable Court in MSA Appeal 3 of 2014 and 265 of 2010. This case is already covered by the decisions passed by this honorable court in the analogous appeals.
Which one?
I have the copy, MSC Appeal 3 of 14 and 265 of 10.
So there is no violation that has been there.
Yes.
Now, you are challenging this only on what ground?
On the ground that this was a private vehicle and was being used as for commercial purpose. So we are relying on one evidence of the Charkiram. He has said that the vehicle was taken on hire, but that could not be proved ultimately. We had adduced we are relying on the evidence of one Charkiram Ray. So he had given the evidence that the vehicle was taken for hire and reward. However, that could not be proved by the insurance company.
The only ground taken is this, na? That is the only ground,
The
not on
violation
quantum,
of policy condition.
not on quantum.
No.
So if that is so, here, how many persons were there
In the vehicle.
in the vehicle? Because 1, 2,
There are total 6 cases, Lordship.
3, how many people?
6 appeals total filed. There were total 6 appeals. So out of 4 we have given judgments, Lordship, here. One we could not trace out this 260. 4 has already been disposed
What
of.
was the vehicle?
Tata Sumo.
Tata Sumo.
Normally 9 plus 1.
Hmm?
Normally 9 plus 1, 10%.
10%.
Normal.
That was not registered as a commercial vehicle.
No, that was a private vehicle, admittedly.
And these are all relatives.
These are all relatives that has come in the evidence. That they were going for conducting one marriage, and for that purpose, these people were boarded in the vehicle. The driver was the son of the owner.
He would not get.
Yes.
He's not, the driver is not here.
Driver is not.
This is also another, what you call passenger.
Passenger.
I heard Mr. S. Dotto, the learned counsel, appearing on behalf of the petitioner. Appellant, Mr.
I'm
S.K. Poddar,
correspondent
who
number 1
appears
on behalf of DC now.
the respond number.
1. On behalf of Advocate DC now.
What?
I'm appearing on behalf of Advocate DC now.
Mr. Nath, how can he appear? He has given you a wakalat number.
He has given me the authority to appear. No.
He has given you?
Just orally instructed me, Lordship.
Then how can you appear on his behalf? He cannot orally instruct you to appear. You have not signed the wakalatnama.
No, Lord.
Then who appear?
I am for the respondent, but on behalf of each of you.
Again, another one. Hello, none appears on behalf of the respondents. An appeal is filed under section 173 of the Motor Vehicles Act 1988 against the judgment and award dated 29/5/2012 passed by the learned member Motor Accidents Claims Tribunal, Bongaigaon in MAC case number 178/2006. Full stop. The ground of objection so taken in the present memo of appeal is that the claimant, that the deceased, the deceased was a gratuitous passenger. Full stop. It is relevant to take note of that along with the claim proceedings, there were another five claim proceedings filed. Wherein also similar awards were being passed by the learned Motor Accidents Claims Tribunal, FTC Bongaigaon, holding inter alia that the passengers were not, the passengers in the ill-fated vehicle were not gratuitous passengers. Full stop. It is further seen that there against the appellant insurance company have filed 4 appeals before this court, which were registered and numbered as MAC 8F 265/2010, MAC App 260/2010, MAC App 2020/2010, and MAC App 3/2014. Full stop. This court, by a judgment and order dated 23/5/2018, disposed of MAC App 265/2010 and MAC App 260/2010 and MAC App 20/2010, holding inter alia that the evidence which was produced by the appellant insurance company was not sufficient to come to a finding that the passengers were gratuitous passengers. Full stop. Paragraph number 11, 12, 13 of the judgment and order dated 23/5/2018 in MAC Act 265/2010 being relevant is reproduced hereunder. This court further finds it also relevant to take note of that by another judgment and order passed by the coordinate bench dated 22/9/2022 in MAC App 3/2014, the said appeal was also dismissed, holding inter alia that there was no violation of the conditions of the policy, and hence the appellant insurance company was exclusively liable to indemnify the insurer and satisfy the award. Full stop. Taking into account the observations and findings made by the learned coordinate bench in the above two judgments and orders, and the ground of objection so taken is the same in the present appeal, this court is also of the view that there was no violation of the terms and conditions of the insurance policy, and as such, the appellant insurance company was rightly held to be held liable to, and accordingly, the learned tribunal was justified in settling the entire liability upon the appellant insurance company. Full stop. Accordingly, the instant appeal also stands dismissed. Full stop. This court further directs the appellant insurance company to deposit the amount. Have you deposited any amount here? Stay? I'm not sure. deposit the amount as directed by the learned tribunal. In MAC case number 136/2005, that is rupees 5,11,040, isn't it?
This is MSc in relation to MSc case 178.
Is it 170?
170.
Which appeal I am taking up?
This
It is
appeal
3/17
3 of
Today's-
17.
Yeah.
3 of 17.
3 of 17. Appeal number. The MSc appeal number 178/06. That is an amount of rupees. How much is that?
2,20,008.
2,20,850. Along with interest from the date of filing of the claim proceedings before the learned tribunal within 6 weeks from the date of the present order. It is observed that if any deposit have been made in the meantime, the same be adjusted accordingly. Full stop. This court further observes that upon deposit being made and an order being taken and an acknowledgement a deposit being made before the learned tribunal and before the learned tribunal and the same being duly noted by way of an order but passed by the learned tribunal being produced before the registry. The petitioner herein, the appellant herein will be entitled to the statutory deposit.
Obliged.
Obliged, no.
So are you appearing on yourself or what?
On behalf of senior, sir.
No senior. Non-appeal.
Item 58 fixed at 2 p.m. Item 58.
But file an application under 47. One thing that I have to point out, the judgment, kindly take up page 61. Relevant portion. No? This is the judgment and judgment.
Yes.
Basically, I'm trying to indicate that page number 61, this is the case of the plaintiff respondent here. Court has noted, my lord. The suit is for hence the plaintiff instituted this suit for a decree of declaration that the plaintiff is entitled to get decree for realization of rupees 2,75,000 with interest at 18%. That was his case. And accordingly, issue number 4 was also framed at page number 63. Issue number 4, whether the plaintiff is entitled to get the degree for realization of amount of rupees 2,75,000 at page 63. Issue number 4. And the decree, my lord, ultimately the judgment, kindly see page number 66. Decree was passed that in view of the above, it is held, page number 66, third para. it is held that the plaintiff is entitled to get the actual balance amount out of total amount of rupees 5,65,000 after adjustment of the amount already received. Thereafter,
How do I exercise power? Tell me. No,
Well,
tell me. I understand. He's wrong.
para, page
No, I understand. You said that 5,65,000 was the total work order. You have already done 2,90,000,
it is paid,
isn't it?
it is paid, Lordship.
And received 2,90,000. So the remaining part you were entitled to. That is 2,75,000.
Now, in fact, the suit.
But
was-
what the court did is directed you to pay 5,65,000.
No, Lord. My respectful submission is kindly see page number 66.
Hmm.
Court has directed in view of the above, it is held that the plaintiff is entitled to get the balance amount. The
To
balance.
get the actual balance amount.
Actual balance amount.
Out of the
actual
total of
balance amount
rupees-
Out of the total amount of rupees 565,
Ah.
after adjustment of the amount already received.
Ah.
So again, matlab, page number 66, sorry, 68. So the
67.
67, the suit is decreed with cost for recovery of the balance amount out of rupees 565 after adjustment of the amount already received.
Hmm.
Kindly see the suit is valued at rupees 2,75,000, the page number 68,
Hmm.
this is the decree.
Hmm.
Claim for suit is valued at rupees 2,75,000 for the purpose of jurisdiction and ad valorem court fee paid thereon.
Understood. Everything is understood. Then why you are not filing 47?
Number
What
that-
you see, kindly see page 70.
70,
This is the how much they have put at 5,65,000. This
565.
entire calculation is wrong.
entire is wrong. The-
So therefore, the question should have been 2,75,000 and the applicable interest plus cost. Understood?
But-
But have you filed the 47?
No, they have not. It is not on. And accordingly, that petition was filed at page number 78 from the record I have received, I have seen. They said that this is the amount and already whatever has been paid, after that. Page 70 is the petition. They should have filed a 47 petition.
But this is what the court have already decided. That when the decree was passed to the effect that he's entitled to that. Minus
Already.
after adjustment of whatever he has received.
Lodged.
Then in that remand, gets the remaining amount.
He will get the remaining.
So you must have stated how much he received during the pendency of the suit.
But in fact, it is his case in the page.
Where is his execution application?
Execution
Page
page 70. Page 70, in the record it is there.
Where is the execution application? As per you, how much amount is left?
But in this petition, we have stated given the calculation at para 14, page number 7 in the CRP.
As on date,
As on today, my lord, we have not calculated.
You're not ready.
There is a stay, my lord.
If a person is not ready, then that is the only way of dismissing. Can't help you.
Lord, in fact, we have said that.
Where is your claim petition, execution petition? How much you received, mister? Your this petition is not clear.
Current counsel M.K. Sharma is out of station, as he have stated yesterday. Current counsel M.K. Sharma is out of station today, as he stated yesterday, your lordship. So I have not, this is what I've been instructed, your lordship.
Where is your file?
Lordship, I haven't got the brief, your lordship.
You produce the details as to how much you have paid. File an additional affidavit as of date, if there is any amount.
Well, the,
And or when the amount has to be extinguished.
but whereof,
But the fact remains, the decree is as it is. Decree says that you are to pay this.
lordship,
So if you want to make these statutory deductions and all, you should have challenged the decree,
that is
which you have not. So if this amount of 1,36,000 which you want to deduct on various heads,
lordship.
then it should have, you should have changed the decree. The learned trial court is, executing court is right on that. But what is now to be payable? And you know how it is to be adjusted. That last matter.
While filing this case, my lord, our case is, paragraph 14, we have shown that whatever amount after calculation is payable, we have already tendered the amount.
Huh?
Paragraph 14 of the petition,
Ah.
page number 7 and 8, we have already stated that whatever amount is payable according to us, that has been already tendered in the court on 5/4/2007. Paragraph 14.
Decretal amount as per the court, Iman, amount per the office, Iman, balance is Iman. Income tax deductible, Iman, VAT, FR, forest royalty is 1 lakh,
Yes, sir.
10,000. 1 lakh,
It is 10, it is 1 lakh.
forest royalty, STNF on FR, Iman, higher Iman, total Iman, balance Iman, total recovery Iman, net amount payable. Banker check of rupees so and so was submitted before the civil judge. Calculation at the rate of so and so and the interest of rupees Iman. Iman in Iman. Banker check of rupees here was submitted in the court of Bia. Be that as it may in the objection. Have you taken the banker, have they taken the banker check? No.
I will see the, yes. From the record, I'll
So
see.
as per you, this is it.
This is,
So therefore, the question of VAT and all these things are not there in the degree.
ultimately, these are statutory decrees. That.
But you should
Okay,
have
sir.
challenged it.
That's true, that's true, that's true. I
The
think to
executing
that-
court cannot go this.
That extent, my lord, I agree to that extent. That should have been filed. and-
That should have been categorically stated that it should be only after this. In fact, your written statement should have reflected that. Anyways, his senior is not there.
Yes, yes.
Today the matter could have come to an end, but it cannot, so we stop the interest
Maybe any of them. Maybe any of them.
and adjourn this cyanide. Don't pay. interest, we stop it from today. There shall not be accumulation of interest. It is seen that the council appearing, it is seen the matter was taken up yesterday in presence of both the councils. However, Mr. M.K. Sharma, the learned counsel appearing on behalf of the respondent is not present and seeks for an accommodation. Mr. Dinath submits that the details that there is no dues payable on the basis of the calculation provided in paragraph number 14 of the petition. First, the counsel who appears on behalf of the respondent does not even carry a file and does not know anything about the matter. Considering the above, for the ends of justice, the matter stands adjourned to be listed on 23rd of June 2025 at 2 p.m. Full stop. It is observed that if the respondent is not represented on that date, that too with a file, comma, this court shall proceed with the disposal of the proceedings on the basis of the merits.
Daily list, motion item 26.
Yes, Mr. Mukherjee, what are you challenging?
Worship, the impugned order is at page 61, annexure 6. Prior to this, there was another CRP, Your Worship. The suit
Yes, what happened?
Lordship, the petition was filed under order 16 rule 1A inadvertently. It must have been under 1.3, I understand. Lordship, this was a suit for partition. The ground taken in the WS was that there are other ancestral properties which the other brother is enjoying at Kuch Bihar, West Bengal, and there are some other properties in UK. So a petition was filed to call for the BLRO official, Block Land Revenue official, to show that there are properties in the name of the deceased mother in West Bengal. The petition was rejected on the ground that it was beyond pleadings. If your Lordship has seen the last page here, okay? The learned court says it is beyond pleading. The details of the property was never given in the WS. As such, evidence of the BLRO would go.
Whether it is beyond pleading or not, isn't it the case of the learned trial court to appreciate whether it is beyond pleading at this stage or at the stage of
Stage of final adjudication.
No. These courts are getting very technical. Anyways, heard Mr. issue notice making it returnable on 25th of June 2025. Steps be taken upon the respondent by way of registered as well as usual. So in addition to that, the petitioner is directed to effect service upon the respondent by way of trustee routed through the registry of this court and file an affidavit of service on or before the next date. What is the stage of the suit?
Final hearing. Final hearing.
Arguments completed.
It is for arguments only. Arguments.
What happened on 2-4?
We took an adjournment. It is next fixed on 3/7.
3? You mentioned somewhere.
No, I just checked in the morning. I've just checked in the morning the next day.
By way of the stay, repeat to the registry of this court and file an affidavit of service on or before the next day. First. The petitioner has assailed the order dated 7/3/2025, passed in title suit number 10/2021, whereby an application filed being petition number 1963/2020/23 was rejected on the ground that what the plaintiffs were you are the plaintiff,
Defendant.
but the defendant sought by way of the said application to adduce evidence was beyond the pleadings. Mr. B.J. Mukherjee, the learned counsel, submits that whether it was beyond the pleadings or not, the same could only have been taken into consideration when the evidence is adduced and not prior thereto. He therefore submits that this is a fit case wherein this court is required to exercise supervisory jurisdiction. Taking into account this court have duly perused the order dated 7/3/2025 and I have also taken note of the submission made by Mr. B.J. Mukherjee to the effect that the next date is fixed in the suit on 3/7/2025. And accordingly, this court is of the opinion that the issue raised in the instant proceedings requires an adjudication. Accordingly, this court stays the further proceedings of title suit number 10/2021 pending before the court of the learned civil judge, Junior Division, Kokrajhar, till the next date. Trustee.
27.
Kindly be taken up next week, my lord. The conducting counsel, Mr. A. Ahmed, is out of station.
Who?
Conducting counsel, Mr. A. Ahmed.
Why don't you do it? The counsel for the petitioner submitted request for an accommodation. Accordingly, list the matter next week.
28.
Order at 35 minutes.
This is the judgment of the Supreme Court.
Yes, my lord. This is the
Name? What is the name?
Ashok Kumar Alra.
What did it say?
In bylaw to paragraph 58, 59 and 60. madam.
Hmm?
58.
Yeah.
Paragraph 58, 59 and 60. madam.
The council. Have you read the judgment properly or not? This portion of the judgment is the dissenting judgment.
Yes.
Kindly see the last line of paragraph 16.
Yes.
And this, however, propriety requires that such discussion should be ordinarily be exercised to allow the filing of a counterclaim till the framing of the issues of the hearing. To this extent, I concur with the conclusion reached by my learned brothers.
Yes.
However, for the reasons stated above, I am of the view that in exceptional circumstances, counterclaim may be permitted to be filed after a written statement till the stage of commencement of recording on behalf of the plaintiff.
Yes.
This is the dissenting judgment.
Yes, my lord. And
See paragraph number 21.
21. Our funding, the order 8 rule 6A, CPC does not put an embargo on filing the counterclaim after filing the written statement. Rather, the restriction is only with respect to the accrual of the cause of action. Having said so, this does not give absolute right to the defendant to file the counterclaim with substantive delay, even if the limitation period prescribed has not elapsed. The court has to take into consideration the outer limit for filing the counterclaim, which is back till the issues are framed. The court in such cases have the discretion to entertain filing of the counterclaim after taking into consideration and evaluation inclusive factors provided below, which are only illustrative though not exhaustive. Period of delay. Prescribed limitation for the cause of action pleaded. Reason for the delay. Defendant's assertion of his right.
Counter court has to take into consideration the outer limit for filing the counterclaim which is paid till issues are framed.
Yes.
This is the majority.
Majority, my lord.
And the dissenting is says that even beyond the issues are framed till recording of evidence that is permissible.
Yes.
So which I should follow?
In our,
The majority.
my lord,
Majority means you don't have a case.
but my lord, in exceptional circumstances, my lord,
File a suit.
my lord. we
File
can-
a separate suit.
Yes, we can file.
No,
separate
why you are
suit.
filing other way? You file a separate suit and then go for
Yes.
application under 151 for both together.
Yes, that is why, my lord, paragraph 59 is explained, my lord. To reduce the multiplicity of
But that only the dissenting judgment is there.
this individual,
How can I say this is wrong?
my lord.
Withdraw, dismiss, which one?
My lord, withdraw, my lord, with liberty to file a claim.
You are always at liberty.
Yes, my lord.
Mr.
M. Hussain, my lord.
M. Hussain, the learned counsel appearing on behalf of the petitioner, submits that the instant that he would not like to press the this is an application filed under Article 227 of the Constitution challenging the order dated 18-1-2025 passed in Mize case number 123 of 2024 arising out of title suit number
Title suit number, my lord, 39 of 21.
239 of 2021. He submits that taking into account the judgment of the Supreme Court in the case of Ashok Kumar Karla versus Wing Commander Surendra Agnihotri and others reported in 2022 SCC 394, he would not like to press the instant petition. He, however, submits that the withdrawal of the instant petition should not affect the petitioner to approve to file a separate suit. So taking into account the above, the instant proceeding stands closed on withdrawal. Full stop. It is observed that withdrawal of the instant proceeding shall not affect the petitioner to file a separate suit if so advised.
Obliged.
29,
Yes. 74 is the impugned order, my lord, whereby the additional evidence under order 41 rule 27 was allowed at the appellate stage, my lord.
only exhibit 5, that is the cell deed which they ought to have been produced in original, my lord, that was allowed. My contention is that I have challenged that cell deed also, saying that this daughter who has sold out the land, they have right only 5 bighas of land, but at the time of execution they have mentioned 7 bigha. But when the cell deed was executed, they are in possession of 5 bigha, and remaining 2 bigha, one of the son sold to me. Now they want to introduce that cell deed. There is no dispute with regard to cell deed, but only dispute is whether that cell deed is with respect to 2 bighas is fraudulent or not. So if this document is introduced now at this stage, I may be allowed to cross-examine them. That part is not allowed.
Is there? The
Rebuttal
defendant may give
evidence.
rebuttal evidence.
Rebuttal evidence is allowed, but regarding cross-examination part,
We make it clear.
yes. Because I will have to cross-examine them. And the case is fixed.
Heard
on
Mr.
11
S.K. Ghosh, the learned counsel appearing on behalf of the petitioner. The petitioner have assailed the order dated, has invoked the supervisory jurisdiction of this court, assailing the order dated 23/5/2025.
25-3.
25/3/2025. Passed in title appeal number 03/2014, whereby the learned first appellate court, learned court of the civil judge senior division Nagaon, Assam, that is the learned first appellate court, had permitted the petitioner and the appellants to introduce the original sale deed number 1564/79, dated 26/2/1979. The learned senior counsel appearing on behalf of the petitioner submitted that the instant proceedings have been filed only on a limited score, to the effect that if the petitioner, that while permitting the original sale deed number 1564/79, dated 26/2/1979, the petitioner, who is the respondents in the appeal, may be permitted to cross-examine on the veracity of the said sale deed. This court, having taken into account the limited scope on which the present proceedings have been filed, takes up the instant proceedings for disposal at this motion stage itself. This court further taking into account that the order which the court proposes to pass would not prejudice the respondents herein, do not find it essential for the purpose of issuance of notice. Next. This court have duly perused the order dated 25/3/2025, passed in title appeal number 3/2014 by the learned trial court, first appellate court. The learned first appellate court, after perusal of the materials on record and finding that the deed of sale number 1564/79, dated 26/2/1979, would be necessary for the purpose of passing a judgment in the appeal, have permitted the said original sale deed number 1564/79, dated 26/2/1979, to be used as additional evidence. This court, however, takes note of that if a document is to be adduced, tendered in evidence, the same has to be done through a witness. Accordingly, this court observes and directs that the learned first appellate court shall permit the original sale deed number 1564/79, dated 26/2/1979, to be adduced as evidence, additional evidence in this appeal, subject to the same being tendered through a witness. Upon the said document being tendered through a witness, the appellate petitioners herein would be entitled to cross-examine the witness on the veracity of the said sale deed. this court finds no other. In addition to that, as per the leave, so liberty so granted, the petitioner herein who are the defendants, who are the respondents in the appeal, would also be entitled to adduce rebuttal evidence. First, taking into account the above, the instant proceedings stands disposed. What is the next stage?
Next date, 11/6.
Party,
A copy of this order be produced before the learned First Appellate Court or by 6th of June 2025.
The come against the order dated the day before his tribunal, order dated 8/1/25. Earlier also I filed petition in the auction procedure.
Yes.
He wanted to file additional documents which was refused by the learned court below, and the order is starts from page 12, and the relevant paragraph is second paragraph of page 14, minor.
What amendments you want?
Amendment exactly not, my lord. We have already filed 12 documents.
Huh?
And already we have filed 12 documents. 8 additional documents we wanted to file because he is the auction purchaser, but my lord, he is unable to get possession of the land because of some confusing. The fact is that page 19, your lordship will kindly see. Page 19 of the petition, my lord, that I have given a list
Where
of
is your
documents.
petition?
Page 19 of the petition, my lord. These documents already I have filed, and document number, my lord, next page, page 20, 3, 7, 11, 13, 15, 16, 17 and 18. I want to file it because earlier it was not in my possession.
Why did you take the liberty to file again?
File in
Because
my-
I remember when the matter was moved before me, you took time first. Meaning thereby, I didn't get any good reason for issuance of notice. The next time when it came, you said that you want to withdraw with the liberty.
Earlier I did not, my name was not there, my junior did not inform. That's why you have taken time, my lord.
Huh?
Earlier, when the motion was listed, my lord, that day my junior did not inform me, my name was also not there.
Not that
So they
day.
missed that.
That day too, I have
Second-
said that next,
Yes, sir.
next day.
Next
So
day,
next date also I did not. Then the third date you withdrew.
they appeared, I did not, my lord, enclose the application, my lord, opinion of position filed by the respondent. That's why I have to, this time I have enclosed that, my lord. And our.
Now, which is the
documents also-
petition for which the order was passed?
This is the petition, my lord. That page 18, my lord, annex
Huh?
2.
Page?
Page 18. I file an IA, my lord.
Now, what is the stage of the
Now, my lord,
proceedings?
different IAs are hearing, my lord. It has not gone to the main case. Different IAs, so many.
Who
parties
filed
can
the
hear.
section 17?
This is respondent number 1, if you know one. Respondent number 1,
Who are you?
remove the technology.
Respondent number 1. Canara Bank. No,
You are performer.
No.
Computer Technologies. You are.
No, I'm the performer article number 4 and 5.
You are performer.
Represent the bank.
Hello?
No.
You want the notice? Only a
At this
notice.
time, notice, my lord.
Nothing more
steps-
than that.
Steps maybe, my lord.
No stay.
It's
no
okay,
stay.
my lord. It will take some long time if you lord.
And keeping the maintainability open.
Maintainability, my lord, under section 18 of the, my lord, DRT Act, my lord, that is provision is there. We can find in certain cases 226 and my lord, civil liability also. 27, section 18, my lord.
What does it say?
Did not forget the another file, it is there, my act. They will go into the
Section 18
section 18.
of the DRT.
Yes, my lord.
Certificate.
What is that?
Excellent. Just give me another file. Latest edition.
Hmm?
In the latest edition, it is there, ma'am, section 18.
Any person aggrieved by any order made by the
Yes, sir. Yes, sir.
DRT under section 17.
17, 18.
You may prefer an appeal along with such fee as may be prescribed. Now the question of fee, because it is interlocutory order, that fee is not required. I made
These are recent judgment.
Yes.
no?
Civil appeal number 5290/2025. Sunshine Builders and Developers versus HDFC Bank.
Why you are not going there? File appeal.
Beg your pardon?
Why you are not filing an appeal?
Appeal means, my lord, I have to file a petition, what I'm thinking about, because my lord, the land is there, they have deposited the money, certificate is there, but my lord, the
You are an auction purchaser.
auction price is there.
So you wanted,
been
what do you
problem by the-
want by this application? The order is also so long.
Order is so long,
Why?
but it, observation, your lordship may kindly see in my lord, the observation of the court, my
Read the
lord.
petition
it
first.
says 40.
Where is the petition?
Petition is at my lord, page 18.
Page
Application
18.
for
What is
placing
the number of
of
this
record.
petition?
IA is my lord, 724,
Let us 724, where is the order?
page 18. In SA 107 of 2019.
724. Where is the order of 724?
It starts from page 12, my lord.
Which order?
It's a
724.
long order, my lord.
Long, it has many
Yes.
petitions.
But your lordship can read, my lord. Page 14, last paragraph I'm reading, my lord. It is
Where is
observed,
724's order?
page
There is
14,
no 724 here.
Yes, sir.
14, my lord.
Where?
In the opening page, that is page number 12.
No,
Page
no,
number
page
12.
number 12 is that
No,
order.
they
Which
have
is the
724.
impugned order?
Heading is there, my lord. Order sheet in the middle column.
Annexure
SM
1 is the
minus
impugned
IA.
order. Annexure 1 is the impugned order.
This is the.
What is the impugned order?
8-1 is the impugned order.
Okay, let us
8
see.
of
what it
January,
is.
page 12.
Case is,
As in the IA. So many IAs are there, my lord. And 2, 3, 4, 5.
24, okay.
8 IAs are disposed of, same order. क्या है? 8 IAs are disposed of. I can tell you.
So they say that these documents have no relevance.
Said that these documents I have not challenged. I am not thinking of my lord that we have to challenge in a writ petition. Because land is there. it has
Another leaf.
mortgage, otherwise, my lord, these documents has to be challenged.
I'll
This-
suit.
This court will, my lord, I don't know how
What,
many years. they
what
will
you
take.
have done is, as I could see, I think suit is the best.
Suit.
Because you are challenging the document, the sale deed of 2007. Are you not challenging the sale deed?
Not challenging, but the said.
That is what has been recorded.
Land is there, everything is there, but they have sent the circle officer has sent they have mortgaged the land to the bank. Bank have sold it to us. But my lord, the debtor, my lord, he has changed the dag number, pata number of the land subsequently. So they said it is not the land. But my lord, as per bank record, it is my land, my lord, but I have purchased. So my lord, I think my lord, a writ petition has to be filed asking the circle officer and deputy commissioner to clarify. Because why they have changed letter? They've changed the dag number, pata number on their application.
So what do I
Although
do?
they have purchased it.
What
So
do I
he's
do
unable
with
to
it?
take position. And they are also, my lord, playing an important role, although my lord, I am buying it from the bank. So bank should have come forward and give my position. They have also failed to take any steps for delivering the land.
Because there is the surface is pending. There is
Purpose, I have nothing to do because I have not taken loan from the bank.
okay, it's not that. Surface is pending.
That is
There
the
is
issue.
a RESCO order. The auction purchaser has implemented himself as respondent number 5. They have filed their respective objections and all those things. Matter is at the final hearing. Now the question here is that, as my learned friend has said, that there is a change of dag number, but it's not that.
Remember now, wait.
Yes.
I now remember somebody appeared out here.
Yes. There are
This
two lands.
the land which is there,
Yes.
which was sold, was across the road.
Yes, correct.
Yes,
And part of that, now what has happened, the road had changed.
Yes,
yes.
And therefore the land area has changed.
Yes.
As to whether it is inside the
Yes.
road or beyond the road.
It
That's
doesn't
the
matter.
question.
That's
huh?
one, exactly.
Exactly.
Now what has happened here? Now what has happened, Lottie? That part, they have challenged before the DRT, that 756, that is a separate land. Challenge that this, that particular sale deed is false. They have filed an application, IA, and they have challenged it. And that, and the last occasion it was hard there, it was hard. And they had also prayed for forensic examination, though they have carried out a private forensic examination. So this is the situation now.
So what should we do?
Oh, my lord, at least, my lord, there the additional documents, there are so many decisions and others are there. At any stage, my lord, before delivering the judgment, now the hearing has not.
No, the
also
question
completed.
is, are
The
you
document
challenging
should,
your basic case, as I can gather,
yes,
is
my lord.
that they had mortgaged a plot of land which was inside the road.
Yes.
Now, with manipulation by this Brahmaputra, they have put the dag number beyond the road.
Yes, my
Isn't
lord.
it your case?
Exactly, my lord.
Uh-huh.
Now they are,
And therefore, but why are you challenging the sale deed? The sale deed, if you challenge, that will go away, everything will go.
we'll
Don't
talk
you
to
think
the,
so?
That's, that
Land, my
particular
lord,
sale
because
deed, Lordship,
earlier
that
I'm
particular
not
sale deed,
attending-
but that land is not mortgaged. That is not mortgage.
that is not mortgage.
Our mortgage is different. There is no doubt about it.
No, I understand. That sale deed is another sale
Eh,
being
yes,
done
and-
by
and they
Brahmaputra
are saying
to
that,
others.
portion of land had crossed the national highway, and they are saying that the ingress and out, an egress portion, which is not claimed anywhere, they are claiming that that is the part of the land. So the moment the Brahmaputra gets hold of that particular
Do
portion,
one thing, madam. We issue notice and say that the pendency of the instant proceedings shall not bar
yes,
the tribunal to go ahead with the proceedings.
yes,
They are not sitting, I don't know how many years. it
no,
will
they're
take.
coming in fourth. Will be coming in fourth.
No, that
This
is the
for
best
half an
order.
hour. I'm not appearing there. but-
And also give you liberty to proceed in any other forum.
Already they have filed one application in the, before the title suit is pending.
Title suit you have filed.
Yes, they have filed.
No, I don't know, my lord. That is not informed by them, my lord. They're businessmen, they have informed, have the informed, it is very difficult, my lord. But
Okay, okay.
About the
We'll
title,
do
sir,
one
I
thing.
don't know
No,
here.
madam, you do one thing.
Yes, ma'am.
We just issue notice, nothing more. Keeping the
Issue and, no,
maintainability.
your lordship has spoken now, no, dependency of the, yes, ma'am. That may be given, ma'am. At least some protection.
No protection. In
Dependency of
fact,
the
I
member.
allow,
Under, so they are going.
I will allow them to proceed. There is no protection. I make it clear that they
Allow
should
them to
proceed.
sit.
Yes, because you see, if I stay their proceedings, they have obtained the stay. If they not obtained the
Yes, yes,
stay,
yes.
which is going to go against you.
Because we are trying
Yeah.
best to expedite the matter.
They are trying their best.
No, this is DRT matter.
DRT matter.
Yes. We are
DRT
trying
Or
our
should
best.
we, or madam, should we adjourn this matter for some time? To think about.
After one month,
Let
I'll
us,
give-
let
I'll-
us,
I'll give you
let us
some
have it after the monsoons are over.
No, my lord.
Huh?
No, my lord, I want to leave practice as your lordship, no, my lord. So, my lord, whatever cases are there, I want to finish as early as possible and I, hands off, my lord.
If you want to leave practice and you want to, I can complete the matter today itself by dismissing it.
It is not, my lord.
Because obviously appeal here is against this.
Certain cases are there, I have to finish.
Taking into account that you don't leave the practice, I was about to issue a notice only.
Your lordship can issue notice.
Only notice. Issue notice making it returnable on 27th of June 2025. Steps be taken upon the respondent numbers 1, 2, and 3 by way of registered as well as usual. As regards the respondent number, as regards respondent number 4 and 5, Mr. So-and-so appears and accepts notice. Extra copy of the instant proceedings shall be, of the petition be served upon him by within 2 days, by Monday. Because the petitioner herein have assailed the order dated 8/1/2025, passed in I number 724/2024, whereby the various applications which the various documents which the petitioner wanted to bring on record was not permitted. Footstop. This court is not in footstop. This court shall pass only appropriate orders after the service is complete upon the respondent numbers 1, 2, and 3, who are the petitioner applicants in a proceedings under section 17 filed under the Safasai Act. Footstop. Footstop. This court further observes that the pendency of the instant proceeding shall not bar the DRT Guwahati to proceed with the adjudication of SA case number 107/2009.
Hello.
Only the last day of the court, I think, 27 June.
That is why I put
Vacation.
it.
That's why when any prior date may be given, 24 Monday. Yes, I will be able to come.
26. 1 day before.
Okay, my lord. Justice service also given, my lord.
And you and Dusty?
Yes, my lord, because the advocate is here. only.
Dusty. Liberty takes steps. Yes, what are you challenging?
Actually, the order dated one annexure 6, page number 50, 1/2025.
is the stage of the suit?
Cross-examination
Of
of the plaintiff witness. During the cross-examination on the
So you want to make it not second floor, third floor?
third, second floor is his residence.
This came into light when you understood that it is ground floor. The first, second floor is where you are residing.
Yes.
Third floor are the commercial
And the
tenants.
commercial, and the dispute relating to title suit is only related to the ground floor. Dispute which we have filed for the title suit, it's regarding only for the ground floor, it is not in dispute, the first floor and third floor, it is not in dispute, Lordship. The schedule, Lordship may have a look at it.
Where is your plane?
I have annexed it, annexure 1, Lordship, page number 23, Lordship. Schedule B premises,
Ejectment.
Lordship.
On the ground floor.
Lordship, ground floor.
Why do you need that then amendment? Why do you need that amendment?
For the sake. Because in the cross-examination, they were asking some questions relating to first floor and third floor.
Which paragraph you want to change in the plane?
Paragraph number 6.
Huh?
Paragraph number 6.
But Mr. So-and-so, the learned issue notice making it returnable on 25th of June 2025. Steps be taken by way of registered as well as usual. So in addition to that, the petitioner is also within 3 days. Petitioner is also directed to take steps by way of dusty upon the respondent number, sole respondent. Put it through the court and the petitioner herein have assailed the order dated 1/2/2025, whereby an application filed under 151 seeking an error, seeking correction of an error in mentioning the floor number in paragraph number 6 of the plaint was rejected. The learned counsel submitted that though the application was filed under section 151, which ought to have been under order 6 rule 17, but taking into account the judgment of the Supreme Court in the case of so-and-so versus so-and-so reported in 2018 6 SSC page 24, he submitted that the application can very well be construed to be an application under order 6 rule 17 of the code. He further submitted that the suit which was filed was for ejectment of the respondent from the ground floor, on account of a mistake, on account of a typographical error in the plaint. The paragraph at paragraph number 6, it was mentioned as first floor and second floor, which ought to have been first floor and third floor. This correction, however, was not allowed on by taking a very hyper-technical approach by the learned trial court, that is the court of the civil judge, junior division number 3, Kamrup Metro at Guwahati. He further submitted that a perusal of the plaint would also show that the said correction in respect to the said correction, that the said correction is necessary for a proper education of the suit, in as much as it touches on the bona fide requirement of the suit premises. For taking into account the above, it is the opinion of the court that the petitioner has been able to make out a case for stay of the further proceedings of title suit number so-and-so pending before the court of so-and-so. Accordingly, the proceedings then stayed till the next date.
Supplementary item
argument in that
54.
manner. You make your case in that manner as I have written in that order. Otherwise, your petition will be dismissed. You can't file 151 like that. Ricky, motion? Yes, what is this? What are you challenging?
Yep, challenge the district judge Kamrup Metros. Husband on order, annexer 7, page number 44.
Why is such a delay? Order was passed in 16/11/2022. You have filed it when?
Uh,
2023.
IA civil was pending and that was allowed.
Huh?
IA civil was pending
Why?
for the condonation of delay.
Why there was a condonation of delay required?
And there is always few days delay to filing the civil division petition due to the illness.
You
of
have
the
wrongly filed it
petitioner.
under 115. You should have filed under 227.
And one,
Anyways,
earlier one day was, it
what
was,
injunction you require?
we want to pass a order to open the gate that is on the way to the water tank, the top floor. I am the tenant and my tenancy is for restaurant and that is in the first floor. And in the top floor, third floor, there is a water tank. And the landlord is taking the charge of the water, but is not supplying. We are purchasing the water, but cannot clean the water, as it is locked by the landlord. And it is a restaurant, cleaning water is very essential.
Issue notice making it returnable on 25/6/2025. Steps be taken upon the respondent by way of registered as well as usual. Full stop. The petitioner is also given the liberty to take steps upon the respondent by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. At the outset, the learned counsel appearing on behalf of the petitioner had submitted that the instant application ought to have been under Article 227 of the Constitution, taking into account that Section 115 of the Code would not of the Code of Civil Procedure 1908 would not be maintainable. So taking into account the above, the instant proceedings is taken as a proceedings under Article 227 of the Constitution. Full stop. The petitioner herein have assailed the order dated 16/11/2022 passed in Miss Appeal number 27/2019, whereby the appeal filed by the petitioner was rejected by the learned First Appellate Court, rejected by the learned Session Judge, the learned District Judge Kamrup Metro at Guwahati, thereby affirming the order of rejection of the application filed under Order 39, Rule 1 and 2 by the petitioner. Full stop. This court would hear the learned, this court can only pass an order in the instant proceedings after hearing the other side, and as such, any order to be passed shall be only considered on the next day. You take your steps in that regard, then we'll see what can be done. That is why I have given you dusty. So if you effect service by way of dusty, then now we can take it up.
Daily list item 32 for admission.
petition is against, my lord. Okay, what happens, my lord, we file title suit.
You're challenging which one?
Uh, order dated 6/12/23, my lord.
612. 410.
410, my lord.
What is wrong with that order?
Yes, I'll take your lordship to that, my lord. Here, what happens, my lord, in this matter, at the argument stage, my lord, I'll take your lordship to the facts of the case, my lord. That is, we filed this suit on 22/9/15. Title suit we filed. They filed WS. In their WS, my lord, they took the plea of, my lord, they took the plea of permissive possession, my lord. Thereafter, my lord.
Adverse position.
They took the plea of permissive possession. Initially, my lord, in the WS. Thereafter, my lord, issues were framed, evidence was taken, my lord. Cross-examination was done, my lord.
No, they have filed a counterclaim.
They have taken the plea of,
Adverse position.
subsequently, that is my case, my lord. Subsequently, they take the plea of adverse position.
No, I'm saying whether they have taken the plea subsequently is not the question. The question is they have filed a counterclaim.
Counter.
And in the counterclaim, the only issue which was framed at that point of time was whether the counterclaim was maintainable. Then the question, if they filed a petition, that you have only put that question out there that whether the counterclaim is maintainable. Well, when there are pleadings to the effect that we are in possession, uninterrupted possession, and our right of adverse possession is there.
Permissive possession, my lord, that is not adverse possession.
No, they are saying whether the defendant is in, let us see the counterclaim.
I'm taking a logic. Annexure 2, my lord. Annexure 2, page 21, my lord.
Written statement.
Yes, my lord. Paragraph 12.
Counterclaim.
Counterclaim, my lord.
Counterclaim is valued as so and so. Filed on so and the death of so and so, some portions were required by the government. That under the occupation, here it is a open continuous and here in the defendant has the right to. So they have taken the plea of adverse possession, paragraph number 13, page 34.
Initially, my lord, they took the plea of adverse possession, my lord. Subsequently, my lord.
But they
And I
have
will
taken
take
it
your-
at the
I will-
time of
I will-
filing the counterclaim.
I will take a lawsuit to paragraph 30, my lord. Paragraph 3.
No, did they not file, whether they have right or not, that's a different thing. But on the same date, when they filed the written statement, they filed the counterclaim separately. Now, if you see paragraph 13, page 34, yes. Only see page 34, paragraph 13,
That is at page, my lord.
paragraph 13, page 34.
Page 30, more paragraph 13, my lord.
34, paragraph 13.
That under the circumstances, it is necessary to declare that the 40 years old, open, continuous, uninterrupted, notorious, and hostile possession of the defendant has ripened into ownership against the right, title, and interest of the defendant.
And paragraph, page 35, relief number 2.
Yes. It is therefore prayed that your honor may be pleased to consider the facts and circumstances mentioned above and be pleased to allow and declare a counterclaim. Declare the right, title, and interest and ownership of the plaintiff by right of adverse position. Subsequently, they taken this plea of adverse position. And that is whether.
No, they have taken the plea of adverse possession at the time of filing the counterclaim.
On that, they filed that plea they have taken, my lord.
Now, if they have taken the plea for counterclaim, then there should have been an issue as to whether the suit is barred by limitation, number two, as to whether the suit is, whether he has got a title, because now after the recent judgment of the Supreme Court, on the basis of adverse possession, one can file a suit for adverse possession.
No, I will take, I will take your lordship to page 21, paragraph 12. Page 21,
Yes.
page 21, paragraph 12.
Hmm.
That is in the written statement, initially their stand was, my lord, written statement, that the averment made in paragraph 4 of the plaint are partly admitted and partly denied by the defendant. It is true that Dharmakanta Borua was the original owner of a plot of land measuring 0 bigha 2 kotha 10 lesa, covered by Dak number so-and-so, situated at Amlapati Dibrugarh. The fact is that the plaintiff, along with his brother, Jitendranath Borua, since this is inherited the said plot of land after the late of Dharmakanta Borua, and after that he, along with his brother, Jitendranath Borua, sold the same to the mother of the defendant, namely Putuli Datta, since this is wife of late so-and-so, Amlapati so-and-so, for a consideration of rupees 200, my lord. This is permissive possession. By executing a Kacha deed of money receipt on 17/3/86. So, my lord, this is permissive possession. That is in the written statement. Subsequently, they have taken the plea of adverse possession.
It is on the same date they have taken the plea. Whether the plea is maintainable or not, that is for the trial court to decide. Now the question is, what were the issues which were framed initially by the learned trial court? Where are those?
That is only one issue, my lord.
Page? No. The entire issues.
Entire issue. I think your lordship will get, my lord. Initially. Before that, I will take your lordship to 38/118 order, my lord. Section 4.
Page?
38.
38.
That is regarding counter claim, my lord.
Written statement filed by you have filed the counter.
Yes.
Yes, that I've understood, but where are the issues?
Yeah, issues I am taking, my lord. Initially, my lord, there is only one issue, my lord, whether the counter claim is maintainable, and therefore subsequently, my lord, issues were filed. At page 60.
These are the amended issues.
Amended issue. And my submission before lordship is that, my lord.
Because if these issues are not framed, madam, if you win the case tomorrow on the appeal, this is going to get remanded. The main problem, this is going to arise because there was a fault on the part of the court in not framing the issue when there is a counterclaim. At the end of the day, you will be suffering more.
That is there.
Because tomorrow they will say that they have not issued and made only, they have only gone into the question of maintainability.
Take your lordship to the order that is 6623. That is the suit fixed for argument, my lord.
6 page.
Before that, if your lordship permits me, I will take your lordship to 4123. That is the order, my lord, input order.
I've read that 4123.
And my lord, the matter has been fixed on 31/10/23 for additional evidence of counterclaim, my lord.
Because madam, what will happen is this. Why this is being done is kindly see order 18 rule 3 of the CPC.
That will, it,
Order 18 rule 3. What happens is like this, madam. Order 18 rule 1 says the right to begin. Order 18 rule 2 says the manner in which the recording of evidence will take place. Order 18 rule 3 is a very important provision which I don't think most of the PAL courts follow, but here this court had followed. Because here it is his right to prove adverse possession. So he has been given the right to adduce additional evidence. And you have a right to cross. And you must have got a stay. Stay of the suit. So they are happy, they are therefore not appearing.
appropriate order, my lord, remanding the matter.
No, therefore,
Or
the
for-
question of interfering with this order would not be proper. Taking into account if they adduce evidence, you will also have a right to adduce a rebuttal evidence,
But my lord,
including cross-examination. But it should be done. It should not give in, it should be complete, the evidence has to be completed within 3 months. I think that is the fair thing. Nothing more than that.
what happens? Evidence of PW1, PW2, PW2 were recorded, my lord. Evidence of DW1 also recorded, my lord. Cross-examination was done, and suit was fixed for argument on 6/6/23, my lord. And what happens on 6/6/2023, my lord? They came up with a petition under Order 15 Rule 5 and Order 18 Rule 17, my lord.
Actually, order 18 rule 17 would not come into the picture.
That is, court may recall and.
Order 18, but the question is, because the order 18 rule 17 only says about recalling of witnesses by the court. And taking into account the Viraswami's judgment, it is absolutely the prerogative of the court. But here the question is, the moment you are framing additional issues, they get an opportunity in view of order 18 rule 3. And you will have a right of rebuttal unless you say that yes, the evidence is already there on record. Why do you need? Yes, the court can frame issues at any point of time, but that does not give him a right. But at the end of the day, if that is an order being passed out there by that court out there, and this court affirms to that effect, means it interferes with that order, tomorrow his only case is that I was not permitted. That would be a loophole which will remain for all times.
That I leave your lordship, my lord, your lordship will. Regarding my lord, permissive position and my lord advisory position, my lord, may I hide a decision, my lord?
Not necessary. Taking into account, I am not going to decide. If I remain here, I will decide one day as a second appeal. Counsel appearing on behalf of the petition. The supervisory jurisdiction, none has appeared on behalf of the respondents in spite of notice being served. The petitioner herein have assailed the order dated 4/10/2023 passed in title suit number 235 of 2015 by the Court of the Learned Civil Judge, Junior Division number 2, Dibrugarh, hereinafter referred to as the Learned Trial Court, whereby the Learned Trial Court had framed three additional issues. Two additional, no?
Initially one, subsequently this is.
No, that
60
is
million.
the,
Six.
two additional issues. By the impugned order, and further permitted the defendants who were the counterclaimants to adduce additional evidence. Full stop. This court have duly taken note of that prior to the framing of the additional issues by the order dated 4/10/2023, the suit was at the stage of arguments. And both the plaintiff as well as the defendants have already adduced evidence. This court further have perused the provisions of Order 15, Rule 5 of the Code, which permits the court to frame any issue prior to the passing of the decree. Therefore, as regards framing of additional issues by the impugned order dated 4/10/2023 requires no interference. However, this court finds no justification in the order dated 4/10/2023 as to why the counterclaimant should be allowed to adduce additional evidence, taking into account both the plaintiff as well as the defendants were very much aware about their case at the stage of, at the time of adducing the evidence. First, considering the above, this court, while not interfering with the order dated 4/10/2023, by which the additional evidence were framed, directs the Learned Trial Court to examine as to whether any additional evidence is required in the said suit to be filed, taking into account that both the plaintiff and the defendants were very much aware as to why, as to the filing of the suit as well as the counterclaim, and what was the dispute involved. More so, taking into account the petition so filed by the defendant dated 6/6/2023 do not mention as to why additional evidence is required to be adduced. First of taking into account the above, the instant petition stands disposed of with the following observations and directions. Number one, this court is not interfering with the order dated 4/10/2023, passed in title suit number 235 of 2015, insofar as framing additional issue number 6 and 7. Number two, this court, however, interferes with the order dated 4/10/2023 insofar as permitting the counterclaimant to adduce additional evidence without assigning any reasons, and that too when nothing has been mentioned in the petition filed by the counterclaimant as to why additional evidence is required. Full stop. Under such circumstances, this court therefore directs the learned trial court to examine that on the basis of the evidence already there on record, whether any additional evidence is required, and more particularly, if there is an appropriate application being filed, any additional evidence is required. Full stop. Full stop. This court further takes note of that by an order dated 6/12/2023, the further proceedings of title suit number 235 of the 2015 pending before the learned trial court was stayed. The said stay order stands vacated, and the petition and the parties herein are directed to appear before the learned trial court on 2nd of July 2025 for further proceedings of the suit. On that date, the petitioner, who is the plaintiff in the suit, shall produce a certified copy of the order, and the learned trial court shall proceed with the disposal of the suit in the manner and in terms with the observations and the manner directed herein above. Full stop. It is also taken note of that the respondents have not appeared in spite of notice. Under such circumstances, the learned trial court shall also issue notice about the date so fixed and accordingly proceed with the suit. I think this is the only best order, otherwise.
33,
Oh, your matter. Mr. Dutta only comes in these type of matters. He doesn't come in other small types of. That matter today, why he has not moved under section 30 of the recovery.
My junior colleague, my lord, he did not give me a copy of the, and he wanted that I should move it. That's the problem.
But he takes the adjournment in your name.
Yes, sir. I don't know, I told him I'm not doing that, then I came to know that he has said that. It's not very fair.
Yes. Your thing is that there was an injunction passed and you have already raised certain constructions and it is half done when you got that injunction. Your thing is that you have purchased the suit land.
2003.
2003. And you have been, and thereupon you have started the construction.
After burning down the house, Assam type house was burned down.
Huh?
Assam type house was burned. Thereafter, after taking permission from the authority, I have started construction for opening my shop, where my shop was gutted by fire. And they have said that we should purchase the property in the name of the HUF. We have purchased the property in the name of firm, partnership firm, considering the fact that there is a HUF in the name of Badriraj Pandalal. But according to them, they were regarding the purchase of the land in 2008 itself. And they have, their father also were regarding purchase of the land in question before his death.
So what are you constructing?
I'm constructing my shop house. Shop house.
Shop house?
There is a shop, clothes shop in the
shop.
Clothes shop in the market. That was burned down. Thereafter, I have started construction after taking necessary permission from the authority. And they have.
And when did you get your mutation done?
2003. And they have admitted in their petition that HUF between us has been dissolved by deed of partition. And thereafter said the earlier HUF was existent, Badriraj Pandalal was in existence. That is why they are claiming that they want to pay 50% of the price, claiming their right over the property as an HUF. But without accepting the money, I have purchased the property being a quota in my own name, in the name of a partnership firm, and concealing the fact that there is a HUF. That is their claim. And they have admitted that HUF has been dissolved. And they have admitted they are aware regarding purchase of the property by their father itself before his death. Then they have not filed any case. When I have started construction of the building, they have filed this case and obtained the injunction, ex-parte injunction. And when ex-parte injunction was obtained, immediately I filed written statement as well as objection. Honorable Court did not hear the matter. They are calling some document from different courts and others. I have filed
But that day I passed an order there.
to dispose this matter. Then they disposed this matter with a document calling from the municipal board that Bodridas Pannalal was there as a firm or partnership or HUF. And on the basis, learned trial court has passed the present injunction order, restraining us for construction of the building. And they have admitted, Lordship, that HUF between us has been different. And
But they challenged the sale deed
they have challenged the sale deed,
of 2003.
2003. That is time, but. And they have.
And their right over the sale deed, right over the land is dependent on the sale deed
Sale deed,
being set aside.
set aside.
And what is your judgment which you are relying upon on this aspect as regard a sale deed when it is being challenged? The limitation would be what?
Limitation is, let's say, 12 years, and in case of.
Huh?
Limitation for challenging this
Mr.
case.
Goswami, you are not aware of the recent judgment. Why should I help you? Yes. You said that you should have been more, you should have looked into that. You have a direct case on that. Why should I help?
My lord, I'd like to take your lordship certain documents where from your lordship will find they did not come before the honorable court with a clean hand. My lord, whether your lordship will see the partnership deed and the dissolution deed, who are the executants, and they are claiming the lineage in the name of Sham Sundar, whereas in the appeal petition you will find the lineage is that Sham Lal Agarwal. And then your lordship, another very striking thing, that partnership deed was started on 15/12, executed on 15/12/2003, and it was dissolved on 5/1/2004 after just 22 days. There was no business transaction, nothing of that. Then, my lord, what they did, now
They had the partnership deed.
Yes,
On the basis of that partnership deed, they sold it.
yes, my lord, your lordship kindly see at page 29 in the FAO, your lordship will find there's the partnership deed,
29.
29.
Yes.
This is the deed of partnership dated, your lordship kindly see 15/12/2003. Amongst Srimati Sita Devi Kanoi, wife of Sri Sham Sundar Kanoi. I could not find the reason why they are changing their lineage, lineage. They are Sham Sundar Kanoi, and in the paper book in the FAO at page 2, your lordship can see.
Page
Page 2.
of the memo of appeal.
Yeah, FAO, my lord, yes. Page 2, Sita Devi Kanoi, wife of Sri Shamlal Agarwal. And the number 2 is also Rajesh Kanoi, son of Sri. Now here they are saying Shamlal Agarwal. Now the instrument your lordship kindly see is not that.
Huh?
In the instrument at page 29, your lordship has seen deed of partnership. This is Sham Sundar Kanoi. Now, the person in the instrument.
Let us see your plain.
Yes, that your lordship will find at page 53. ma'am.
Problem happens because you have made him Samlal.
So Shamlal Agarwal, they also saying, but the
No,
instrument
no,
is some.
you only make them in that manner in the plaint.
No, that's okay, my lord, because we are not saying they are Sham Sundar, he is Shamlal. In fact, he is a Shamlal Agarwal. Now, in the instrument, for what reason they have said it is Sham Sundar. Now, if your lordship strictly, if we go to that, now in the PAN card or Aadhaar card, whatever it is, that will be Shamlal Agarwal. So you will have to construe that these are the different persons. With the instrument, they do not have any connection.
This is a mistake committed by him.
No, look, they have endorsed it, the parties have endorsed it.
Huh?
Parties, because your lordship can see the
Because
instrument.
this is being done by him. He made that mistake.
No, he hasn't done that.
He has done that
Your
because it
lordship-
is on a, it is not an affidavit, it is on a certificate.
And in the instrument, your lordship kindly see, there has said Sham Sundar, not Shamlal Agarwal.
That is immaterial. The first is Sitarabai Kanoi and Rajesh Kumar Kanoi.
Yes.
They are there. There was a partnership deed.
Partnership deed, my lord, their name indicates the Sham Sundar, not
That's
Shamlal
okay.
Agarwal.
Then
And then, my lord, they,
with Badrinath Pannalal,
Badrinath Pannalal,
this sale deed
sale deed, yes.
is by
Sale deed, your
done by
lordship will
Devi
find
Prasad Kedia.
at page 34.
Who is Devi Prasad Kedia?
He is the owner, my lord, owner of the land of 8 latches of land.
Okay.
The dispute
So
started.
it was
with
purchased by
this part-
Badrinath Pannalal,
Yes,
registered partnership firm.
registered, they are saying that.
This
it's
was
a
done in 2003
2003,
and this is 512. So just on the date of deed of partnership when it was made,
yes,
deed of partnership was made on Badridas Badridas Patnalal. So this land was purchased.
yes.
Then
Then, my lord, dissolution was on 5/1/2004. That your lordship will find at page 163.
and when did they sell it?
They sold it on 26/1/2003
Where is that?
and dissolved on 5/1/2004.
Sale deed is of 26/12.
26/12, right?
So it was being purchased by this partnership firm.
Yes.
And then
And then dissolved on 5/1/2004, just after 22 days.
5/1/2004.
Yeah.
Okay, then
Now, if the partnership business has been dissolved on 5/1/2004, then how they are saying, my lord, the partnership business continued on 22/2000, my lord, your lordship will find that when the fire broke out at page 244, they are saying the partnership business continued up to 23/3/2022, that is when the fire took place. So if the partnership is already dissolved, how it continues? My lord, these are the things, my lord, the clarification, your lordship will not get it here. So therefore, and then, my lord, they are saying that agreement for family
no,
settlement.
who are you? Who are
I'm-
you?
I'm one of the co-personer, my lord. This is in fact HUF property. And in the sale deed, your lordship.
You are saying it will be a HUF on what basis?
My lord, in fact, the business, we are doing common business, and Shamlal is my elder brother. And the Jagdish Prasad, my lord, he expired, now he is legal heir here. Now, both the persons, they are doing business in that, and this Devi Prasad, he was the owner of that 8 latches of land. Now, there was an understanding.
So there
that-
is no problem with the sale deed being executed by Devi Prasad Kedia.
So this has been in challenge in the suit.
No,
So this-
no. Did Devi Prasad Kedia had the title?
Yes, he had that title. There is no.
So the
dispute.
question is, the fraud you are alleging is in respect to the sale being made not to the HUF, but to the partnership firm,
But to the partnership.
but using the money of the partnership firm,
Yes.
HUF.
HUF.
This is your case?
Yes, this is our case. So therefore, your lordship is saying these are not in, they haven't come in clean hand, because you are saying that you.
How are you showing that this is the use of the money from the partnership, HUF, and not from the partnership firm?
My lord, we have made a statement in our claim. And then, my lord, another thing your lordship kindly see.
And when did you come to know about the deed of sale?
We could come to know in the, my lord, in paragraph 16 of the claim we have stated, in the year 2023, we could come to.
Huh?
2023. In paragraph,
2023.
yes, in para.
Now, all of you are doing business out there in the same place.
No, now, in the same, we are not doing their business. Now, after purchasing it, so-called purchase, they are doing the business in the 8 latches of land. And that is the, my lord, the disputed area. Your lordship says para 16 and 17, the date of our knowledge.
Because it's after all a registered sale deed.
But then, my lord, your lordship, can you see, in fact, I'm taking to your lordship another document.
Now you say the money has been taken from the HUF.
Yes.
What is your basis?
Out of the fund of the HUF, this property was purchased.
Okay. What is your basis?
Basis, my lord, the type of trial only we can.
No, no, but
Prove
then
by
also
basis.
you have to show something to have a prima facie case.
Now, before that, my lord, the way how they have purchased, my lord, I will just take your lordship to few documents. Your lordship may see at page 219. This is the valuation list of municipal.
219 is where?
This is at page 219. The affidavit filed by us.
Ah, 219.
My lord, these are
Yes, what is this?
very difficult to read. Your lordship may see in the middle, Badri Das Pannalal, in the bracket, it is written rent.
Okay.
It was on, in, my lord, from 1, 2, 3, 4, 5, column 5, my lord. Then down your lordship can be seen in the middle part, Badri Das Pannalal.
Hmm.
I'm sorry, my lord, the note that way very legible.
This was done in 2004.
It is, your lordship can see 19, the document, then your lordship will find there is a clause, there is written 1929.
No, it's okay. But if we see 219, there's a name of Sita Devi Kanoi
Yes.
and Rajesh Kanoi.
Now, what they have done, my lord, after purchasing it, they have mutated their name.
So
Now
if they
that-
have done it in the year 2004 or even 2009, let us take it. So you should have known then.
No, we could come to know only 2023 only.
Now,
and
if
we have-
this is the document, if you're relying on, that means you know about
No,
this
we
type
could-
of documents exist.
We could gather recently, my lord, we could come to know that they have purchased that. In the year 2023, we could come to know, and we have obtained these documents from the municipality.
No, but show me how it goes from your funds.
And if this document shows that Badridas Pannalal, it was on rent,
Hmm.
and this document relates to 1921.
Hmm.
Then, my lord, the fact remains, this Badrinath Pannalal, it was an HUF property.
Hmm.
Because it was.
It was a tenant only,
Yes, as tenant.
as tenant.
As tenant.
But
we
what
are
is your
doing
right
our-
of a tenant?
As tenant, we are doing our joint business. Now,
Understood, but the right is now being, the partnership firm becomes the owner.
yes, now it's a.
Is the
replaced
owner.
Yes.
You may have you are maybe a tenant at best.
Yes,
Badrilas, Pannalas, HUF may be a tenant,
tenant.
but you are not in possession.
No, I'm not in possession.
So how are you a tenant?
No, that relevant time I was the tenant.
You were a tenant at both at in 1921 or 29 onwards, you continue to remain in tenant
Till the time they enter into a partnership.
and then took it over. Yes, it's a very ingenuine method where Mr. S.K. Goswami must have lent his ideas on this. But the fact remains, you were neither a tenant.
Now, of course.
Then also, from the
Then
date
at
the
that-
partnership happened,
Before the partnership, I was.
you were there.
Yes.
But after that, although it was
Well,
clandestinely done,
Correct.
and they continued to remain as the tenant, then
Correct.
they became the owner.
Right.
So where you right from?
Now, of course, that's the reason we have filed the suit. To
Where?
establish.
Well, let us see what is your plea.
Plain to your lordship will find it.
So, Mr.
There are 13.
Goswami,
There are
what is
13.
your,
Page 16,
what is the judgment?
Okay, I will give you that one.
page
Limitation, I'll give you.
16 and 17, my lord.
Page 60, para 13, Lordship, can be seen. Page 60, para 13.
What is the relief sought for?
Relief, my lord, your lordship will see at page.
That Badilas is the owner of the premises as described in Schedule A below, which includes the declaration that the plaintiffs are the co-personas of Iman, declaration that the forming of the partnership so-and-so under the name and style of Iman by the are illegal and inoperative. How do you say that partnership is illegal? Is there any bar
My lord, in
of a member of, let us assume, but these
Contested
people were
matter.
members of the HUF. Is there any bar?
Lord, your lordship kindly see the trust have been impinged. The trust we had, because we had an understanding that both of us, we shall purchase that and we shall.
Was
share
there
it.
any agreement?
No, verbally it was, but then still they have done all these things, my lord, behind our back. So he was my elder brother, we had tremendous trust on him. All these thing happens, my lord, in the family dispute, it runs like that only.
I think better take that undertaking and finish it off. If I otherwise hold it, I'll have to set aside the injunction.
And then,
This case is Mr. Rajesh Gupta's case, recently delivered by Justice Dipankar Gupta. Not rating. Mr. Goswami is more into,
I'm sorry, Lordship.
more into what they call insurance. Two stalwarts of insurance matters arguing pure civil matters.
with the help of your lordship.
No, I'm only here to the.
May I submit?
I think Mr. Datta, you take this, if you win the case, then you'll fall. That is the best way out.
My lord, your lordship,
Because otherwise you have a big problem in your suit.
my lord, your lordship, kindly for a while see the application affidavit filed by him at page 2, paragraph 6, I'll just read out, my lord. I undertake that I shall, and on behalf of other applicants, demolish any construction made during the pendency of the suit and handover. Why you are going to demolish, my lord? My lord, your lordship kindly see the thinking.
No.
The intention is not good.
No, that
Yeah.
is the reason why he has done it is because of that. Because you say that he should not construct. You want the vacant possession. As of now, you want the vacant
Now,
possession.
your-
That is why he has given.
I have gone through your lordship judgment. That is very clear, no question of demolition.
Okay, you will give that. But I think you should not give one, all the appellants.
Yes.
Let all the appellants give. Okay?
Beside
So
this,
don't give it on behalf of one. There
Yes.
should be 3 affidavits.
Otherwise, again,
para
this-
13, beside before that, Lordship, para 13, Lordship, can be seen.
Of
They are saying, Lordship, they have purchased this on the basis of HUF property. Para 13 of the page 60. Of the plain,
are you going to give that affidavit or not?
so I have taken the information.
If you don't give, but give it as per that judgment which I have given. no?
Yes.
Where is that? See that.
That's it.
See that, give it in that and give like 3 affidavits.
Yes, yes.
Or ask one affidavit, 3 persons signs.
3%.
We, use the word we. And put it that may demolish or hand over the possession of the constructed premises if they win the case.
Before that, Lordship, can be seen, my permission, para 13 can be seen.
I know that.
say that it's a property.
As I have indicated, you do that. Till that, I think you should let me keep the matter pending. You want the construction, that do that, because otherwise I'll say balance of convenience and all.
No, I
You
just,
want to go ahead with the construction, go ahead.
Lordship, only thing is, Lordship, they have said, what, we have purchased the property from HUF funds. What they have admitted in their petition that property has been purchased by us from our own sources, and they want to pay 50%.
no,
You want
possibly,
to
Para
be-
13. They want to pay 50% of the share. Para 13.
my learned friend
This is
possibly
not an HUF,
confusing. there are many proceeding and another proceeding, 17 letters of land. Both of us purchased from the fund of the HA. That is also pending, Mr.
No, because the HCF must be continuing.
Yes, it is.
HCF has been dissolved, they have.
We let us not go into those. First of all, are you going to file an appeal? In that? Because of the fact that I have been asking Mr. Dotto certain questions, your stance seems to be changing.
Well, these are the questions to be established in the trial court. It's very difficult for me to answer it now.
Today I delivered a judgment on injunction where the trial court granted, I set aside that. But it is a very interesting judgment on a conditional contract, how it is to be done. It's a super specific performance. You must have heard it a long time. On one hand, Mr. Bhaskar Dotto was arguing, on the other hand, Mr. D.K. Mishra was arguing. Anyways,
Judgment
file
is
that.
reported- Judgment is reported. No, today.
Today I have delivered it.
Can I take a look at para 13, at least for more, for my,
Mr. Counsel, you filed that affidavit. Or I can do one thing, I'll have this matter after vacation.
after vacation. Lordship.
After vacation.
Only to Lordship, he has said, Lordship, it was purchased from HCF property, that is why I want to show that para 13. Because they have admitted in their claim that property has been.
So it means that you are not in urgency.
No.
You are asking after vacations, 1 month is there.
Lordship, to take the consent from the other, because he's here, Lordship, the Sanjoy was here, so he's connecting with me.
He has given an undertaking before the court on behalf of the other appellants, and now you are saying that you have to take the consent?
No,
My
no.
goodness.
We have to inform him, Lordship.
Meaning thereby this person doesn't have the authority. Because if you see that judgment out there, which is reported,
Understand, Lordship.
initially it was being filed by one person. I said, no, you cannot do that.
Yes.
Then it has been filed by another person. Then I said, on behalf of the company, one has to, the company also was there. But the company, I suppose. Has to be there. It is seen that pursuant to orders passed by this court on 9/5/2025, an affidavit have been filed on behalf of the appellants, giving certain undertaking. Appellant number?
Appellant number 3.
Appellant number 3, giving certain undertaking for himself as well as the other appellants. But the said undertaking which is being given is not, cannot be said to be an undertaking of the other appellants. Considering the above, this court therefore fixes the matter. You have no urgency.
Urgency is there, Lordship. And urgency is there. Only thing is, Lordship,
6 weeks. 6 weeks. No date. You don't have urgency.
I have urgency, that is why I prayed, Lordship. only
Then
thing-
file it. Then go ahead with the construction. Then the fact that I asked him some questions, that doesn't mean that I have an inclination. Taking into account, you also have to take note of that I am only an appellate jurisdiction.
Understand, Lordship.
My EI is very limited. I am not going to sit on merits on the appeal.
Understand, Lordship.
Put some questions because he was opposing that undertaking also. That is why I put some questions. Well,
After 2 weeks.
on 13th of June, 2025.
Obliged.
In the meantime, such affidavit, undertakings be brought on record by way of. See that undertaking that I shall either demolish or hand over the possession. You have a good case, but then also keep it like.
That should be very specific. Is under the affidavit he has given. The
No,
indication-
therefore, say either demolish or hand over
Yes.
without there being any other further decree from the court. The word is very specific in that one.
The lordship judgment is very clear.
34,
Because then the balance of convenience shifts. And then I say that the balance of convenience is not for granting. Chalo. Who is for the national insurance? Yes.
Lordship, here the insured vehicle was not, was driven there is no license at all, my lord, on the date of accident.
No license.
No license, my lord.
So it's pay and recovery.
There is no pay requirement.
And has the court held that
Yes.
it was without license?
No, my
Obviously,
lord.
no.
No, my lord.
So did the court look into it? Question as to whether there was a driving license or not?
Lordship, the, basically fact is that we did not adduce any evidence. But the police papers, my lord, reflected that the license was expired quite before the accident. Police papers, they have relied upon it.
That is relied on. Did you take the stand in your written statement? If you have not taken the stand, how did it happen?
Lordship, as per section 3, Lordship, of the MV Act, one should have the license. You know,
Understood, but you have to take the plea. Don't you have to take a plea? It doesn't mean you always take a plea that his license is not there.
Yes.
That is always there. Yeah.
As of today, Lordship, we can deposit entire amount, Lordship.
And pass that same order.
Yes.
And if you win the case, then you will be directed to make appropriate steps for recovery. Look at the order did you, huh? No, sir, both order. Appeal admit, eto mo upor kini likhi dibo. Appeal is so and so, so and so. Mr. Tikolita, the learned counsel appearing on behalf of the appellant submits that the only ground of objection taken is that the learned tribunal, while settling the liability upon the appellant insurance company, failed to take into account that there was no valid license, and as such, there was a violation of the terms and conditions of the insurance policy. For which, taking into account the said ground of objection, the instant appeal is admitted, call for the recourse and stay to ase. Bolo eguteki amount pay koribo within 6 weeks, entitled to recover, and then at a line specific in the circumstance that he wins the case, that this court will pass appropriate directions for recovery to be made by the appellant from the owner. So, our both order ase.
35.
Permit is not there, Lordship. Same order.
Same order.
Same order.
Etu khali koile etu agote insurance I disposed. Econo I disposed. Payment with the
Lordship, may I pray that the item number 37 out of the same incident, Lordship, item number 37.
Of
Today's list, my Lord.
which incident?
Item 35 and 37 out of the same incident. Same ground.
Same order type. Same order.
Much.
35 was the ground of no driver license.
This is permit. 35 and 37 permit, Lord. Permit.
35 and 37 is permit. 34 is different.
DL.
DL.
36.
Enhancement?
Yes, Your Honor.
Why?
Deceased person was a retired teacher and his age was 62 years at the time of his death. And this honorable court below has fixed the compensation of 1,08,000 rupees only.
But without taking into consideration that you have that amount, some amount is to be given, no?
Yes.
Because the insurance, the pension, did he die in harness? No. He was a
No,
pensioner.
pension,
What was the age?
62 years.
62 years.
60.
So what is the multiplication factor which should have been there? দেখো, এইটো ওপৰৰ এইখিনি লিখি দিব। So and so. The full ground of objection taken in the instant memo of appeal is that the deceased was a retired teacher and he was drawing a salary of rupees 31,839. Salary of monthly, was drawing a monthly pension of rupees 31,839. The learned counsel submitted that on the ground that the wife, the claimants would be entitled to the family pension. No amount has been awarded on account of the compensation, without taking into account that the amount to be paid as family pension would be much less compared to the monthly pension earned by a pensioner. So taking into account the above, the appeal is admitted. That's the only ground.
And also, he did not consider the dependency of his son, son of the deceased person. Dependency of the deceased person's sons was also not considered. It was stated in the judgment that he was measured, that is why his dependency was not considered.
Loss of consortium not granted.
Loss of consortium is granted, but dependency of only wife was considered.
He didn't give any amount. He did not give a single penny. Did he give a single penny on account of any other compensation? No. He only gave on the conventional heads. So therefore, this ground will take care of everything.
38.
May I please, Your Lordship?
Ground.
Lordship, our ground is that there is no rash negligence on part of our driver. In this case, the case of the claimant is that he was driving a bike and our vehicle has hit him from the behind.
Evidence did you give?
Lordship, the driver has appeared, he has entered the witness box, he has filed his WS, and he has stated that there was no rash negligence on myself. The bike has come and hit me in the back. And the police have also submitted an FR stating that they are unable to arrest the accused driver because the rash negligence has not been proved. And the police have requested the Honorable Trial Court to release him from the case.
Huh?
Release him from the case. Also, the FR copy I have annexed, Lordship, 34, page 33.
So he's not entitled to any amount.
He's not because accidents occurred to the claimant own fault. It's an injury.
So this is not a case of contributory negligence.
No, no.
It is a case of
Sole negligence of the claimant.
is another negligence. No?
Composite negligence. Also, the composite negligence will come if it is a third party and the two vehicles are involved.
The grounds of objection taken in the memo of appeal is that the learned tribunal completely failed to take into account the evidence on record, which would show that there was no negligence on the part of the vehicle insured by the appellant insurance company. He therefore submitted that the entire settling of the liability upon the appellant insurance company, in spite of tendering of evidence in that regard, amounts to failure of jurisdiction. He further submitted that this is a case where the ration and the negligent driving was on the part of the deceased,
He is injured. It's
of the claimant,
Claimant.
of the claimant. And as such, he is not entitled to any compensation from the appellant insurance company. Taking into account the AI is admitted, call for the records. IA issue notice making it returnable on so and so. Returnable it on 25th of June 2000. Let us have it on 16th of July 2025. Steps be taken upon so and so, so and so. yeah, taking into account the grounds of objection taken on so and so. This court have already admitted the appeal. Full stop. This court would like to hear the other side before passing, this court, taking into account the grounds of objection and the appeal having been admitted, this court stays the impugned judgment and decree, judgment and award dated so and so, 26/12/2024, passed in MSC case number 2380/2017, till the next date. Full stop. Upon appearance of the respondents, claimant, who is the respondent number?
Respondent number 1.
Respondent number 1. This court shall consider as to whether any further orders can be passed in the incident proceedings.
Appellate.
39.
Your lordship, in this case, the deceased was a government employee. And so your lordship, a ground of appeal is that the compassionate family pension scheme was not taken into consideration.
You
by
have
the
similar orders? I passed similar orders.
Yes, your lordship.
You have it? Then only I direct only payment of this amount, no?
Yes, your lordship.
Stay of this and payment of the conventional amount of 1,10,000. Till the next date, issue notice. Not this one. The short orders both the same. This aspect has been approved by the Supreme Court now recently. the
Yes, your
judgment.
lordship, in Sunita Krishna and others versus Tekchand and others, as well as in New India versus Sunita Sharma.
It will move both orders, side of, grounds of objection taken on the gate. Police state to 84.
Will admit it, okay?
6 weeks, deposit that 1,10,000
Okay. Your lordship,
along
does
with
it stay?
interest.
Does it stay?
6 weeks, deposit 1,10,000 along with interest.
Okay.
Yes, GI, ISDA.
40.
Yes.
It's a death case, but insurance is appealing. On the ground that the family pension received by the claimant have not been deducted.
Huh?
Yes.
That day I got hold of one judgment out there where it makes it very clear that the by the Supreme Court saying that the amount is to be whatever is found as per normally it is to be taken into account and thereupon deduct at the time in the award and otherwise also at the time of execution that can be done. So here family pension has not been deducted. As per you, how much he is entitled to?
He is entitled to 93,000.
Huh?
93,000. If that is being deducted. Sorry, she is getting pension 50,799.
So
If that is being deducted, the rest of the amount will be 93,000. Because the age of the deceased was 63 years.
was drawing about 50 per month as pension.
Yes.
Then so this annual income,
Yes.
you have to minus it by the family pension.
Yes.
And yeah, so how much it is? As per you,
As per you, this will be 93,000.
they have arrived at 21 lakhs and you are saying 93,000?
No, they have arrived at 22 lakh something.
21 lakhs 33,000.
Yes.
Then
The total compensation is 22 lakh.
we are not concerned with others, they will get it. I'm only concerned with this. What is the calculation? If it is 40 lakh, 50,000 is the taken as the pension.
Page 26 is the calculation.
Huh?
Page 26.
Finally come to page, yeah, to 26,
Yes.
paragraph 26.
Paragraph 20.
Okay.
Yes.
So the calculation has to be as per you. You have to deduct the family pension.
Yes.
What is the family pension?
Family pension is 50,799.
That is the pension, not the family pension. Because this person was earning 50,000.
Yes.
Finally, see paragraph 20. Goes to show that claimant was drawing about 50,000 per month as pension. So is he alive or not?
It's gone.
Claimant,
Claimant is alive. This is gone.
other than that, how much was his pension?
Same amount.
Family pension also same.
Yes. Same.
But had retired.
Retired.
So how can it be same?
So
It cannot be. Family pension cannot be same with the pension unless it is the case of can a family pension be same with the pension? No.
That aspect is silent from the record, my lord.
That aspect you find it out and then do the math.
My lord.
Find it out and come up. What should be the pension? Family pension, because the family pension will get reduced, taking into account the pension is no longer there. The wife will get less amount.
Right.
So that amount has to be deducted out from the main amount, and on the basis of that, the calculation would be. So that would be your admitted amount. So you have to deposit that.
Right.
We find it out. Next step. When?
Next week. Next week. Right.
Because you see the records whether that particular question should have been put. Because she must be getting something.
Right.
Next week, date of the DD. On 6th of June.
Like
41.
Down?
Lordship, only on quantum, Lordship.
How much?
25 lakhs, 85,000, Lordship, injury case. Lordship.
What is your ground?
Lordship, ground, Lordship, awarded one in the various heads are given in the higher side, Lordship, for the.
On which space?
Lordship, 6.
On which basis?
Lordship, medical expenses, the compensation given in the higher side than what actual medical expenses were submitted, Lordship. And in pain and suffering, Lordship, 4 lakhs is awarded.
This is injury.
Injury case.
What is the hazard? It
Okay.
will, ground of objection taken is that the amount which have been awarded is on the higher side without taking into, and as such, it cannot be a just and reasonable compensation. Council further submitted that the medical expenditure so awarded was also not in accordance with, in terms with the evidence which has been adduced. Considering the above, the appeal is admitted, call for a record stay, issue notice, to dispose koribo. Stay subject to deposit of when did a claim petition filed?
Lordship, 2022. 3/38, 2022.
Arbiter ground delivery, the learned council further submitted that there was also no justifiable reason for of a higher interest being imposed at the rate of 9%. Taking into account the here deposit of rupees 20 lakhs, deposit 20 lakhs. It will go more than that. Deposit of, because I'm not saying with interest, shall deposit an amount of rupees 20 lakhs before it will stay subject to deposit of 20 lakhs before the registry of this court, and so shall be entitled to get the release order to prohibit. 6 weeks. To dispose, they I disposed.
42.
The learned member accepted wrong multiplier, Lordship. Because the disease was 60 years 4 months, that is, it should be in the group of 61 to 65, that is, multiplier should be 7, Lordship.
Huh?
It is accepted as 9, multiplier is wrongly accepted, Lordship.
How much it should be
It should be 7, Lordship.
and how much he is entitled to then?
9, then the second point is, Lordship, above 60, as per Panay City's case, Lordship, is not entitled for any future prospect, Lordship.
Understood.
That is
Then
there. And the
how much
monthly
he
income-
entitled to?
And monthly income is also, we have disputed the monthly income, Lordship. Without any evidence, it is accepted 8,500.
How much?
These are the 3 counts, 8,500.
Because there was no income shown.
Yes, no proof, Lordship, no proof. Lordship, can you see?
What was he doing?
He was a hand puller, he was a hand cut puller.
Unskilled.
Yes,
So it's okay. That is okay. Don't worry. So
Then
therefore,
other-
how much it is? As per you?
50.
Okay. The grounds of objection taken in the memo of appeal are that the multiplication factor which have been applied was wrongly done, taking into account the age of the victim, which the learned counsel submits that the appropriate multiplication factor would be 7.
7.
7. In addition to that, the learned counsel, referring to the judgment of the Supreme Court in Pronoseti, submitted that
60.
that judgment of the Supreme Court in the case of National Insurance Company versus Pronoseti and others, reported in 2017-16 SCC 680, the
Paragraph 59.4.
petitioner would not be entitled to, the victim would not have been, the claimants were not entitled to future prospects. Full stop. She therefore submits that. Additionally, another one, you say, no, monthly income is. The learned counsel submitted that the monthly income was also wrongly arrived. Full stop. This court have duly taken note of the paragraph 14 and 15 of the judgment of the learned first tribunal, and is of the opinion that the said ground cannot be made the ground. Said ground of objection is misconceived. Considering the above, the appeal is admitted. Call for the records. Considering the 2 grounds above mentioned, the appeal is admitted. Call for the records. Stay subject to deposit of 50% of the awarded amount along with applicable interest within 6 weeks. Release disposed.
Must apply.
43.
With applicable interest. That in that case, stay 50% with applicable interest and then 6 weeks.
6% is given. 6% is given, Lordship. Tribunal.
Way less. Whatever may be, 6% on that 50% and deposit. Yes, where is Mr. R. Goswami? I dispose. Okay, the appellant is not present, the matter be listed next. Any more matters? Urgent?
Steps by.
Huh?
Steps by registered.
Steps by to give you, steps by registered as well as usual.
If it had for 49, Lordship, interim is there. So interim may be considered.
Interim passed earlier. Well, 49 to CRP Ionic.
Yes.
Oh, yes. Interim order, this the matter again on. Is the service complete?
Yes, Lordship,
Okay.
annexure, Lordship.
Item number
As per
49.
office note dated 11/2/2025, AD received with signature X1, Lordship.
Service of notice upon respondent number one
One.
is not completed.
Complete lordship. In fact, it's wrongly written. Actually, X1 is her signature. Acknowledgement received is there in the, it's
This court
flag.
have seen that the service upon the respondent number, all the respondents are complete. Accordingly, list the
Lordship,
instant application for admission on 11th, in the column of stay matters on 11th of June 2025. The interim order passed earlier shall continue till then.
deeply.
And item number 52,
And lordship, there is analogous, another matter also is there. That also may be.
is the matter along with the. Item number 52, who is there?
52.
There's a stay order.
Yes.
We extend it.
Lordship.
Is there a stay order or not?
Yes, lordship. there is a-
Okay. Item number, service is complete?
Yes, lordship.
Well, the date may be fixed, my lord.
Okay. Item number 52 to be listed again on 11th of June, 13th of June 2025. Interim order passed earlier shall continue till then. Anything else? No more.
Okay, sir.
Next week, Wednesday, Lordship.
Which one?
44, 45, order 41, hearing matter, Lordship.
Urgency?
Already decree was put to execution. I was out from the suit length, Lordship.
They're out.
Yes, Lordship. Delay was condoned after 2 years, Lordship. Senior friend is with me.
44, 45.
Order
yeah.
41 here.
We have it on 20.
Speak, Lordship.
Maybe Lordship, item number supplementary 57. Lordship, I had mentioned it, my lord. Today it has come, my lord. My lord, can this matter be taken up in the next week, any day, my lord? 57 supplementary, this is a, my lord, IA we had filed for that.
I for what?
But it was for early hearing, my lord. What has happened is that because of a REAT appeal, number one, which has been filed in the High Court here, the execution in the RERA has been kept at abeyance because that REAT case has been filed here. So my lord, if Lordship had allowed it last time, but it came today in the supply list by mistake. So if it is taken up in the next week, my lord, any day, my lord, we'll take it up. Today because of paucity of time, my lord.
17th. Because IA is for early hearing, na?
Early hearing and because that thing, that execution is kept in at abeyance, that is why.
There's an application filed for early hearing of the accompanying appeal. Hearing number, RERA appeal number 1/2024. Mr. A. Fukan, appearing on behalf of the
Applicant.
appellants, submits that the matter requires an urgent disposal, taking into account the early disposal. So in that view of the matter, taking into account the above, list this matter again on 17th of June 2025 at 2 p.m.
Well.
Full stop. It is observed that if the appeal cannot be disposed of, full stop, accordingly, the instant application stands exposed. You are paying? Now to the
Deeply obliged.